All right, good morning, everyone. It's Thursday, April 20th, 2023, and this is the regular meeting of the California Fair Political Practices Commission. Ms. Linker, would you please take the roll?
Commissioner Baker?
Here.
Commissioner Wilson?
Here.
Commissioner Wood?
Here.
Chair Madge?
Present. All right, good morning, everyone. Let's go ahead and get started. Item 1, public comment for items not on today's agenda. Do we have any public comment? Hearing and seeing none, we'll proceed to item 2, approval of the March 2023 Commission hearing minutes. Do any commissioners have edits or comments on the minutes? Hearing and seeing none, do we have a motion?
Move to approve.
Second.
Is there any public comment on item 2? Hearing and seeing none, Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Madge?
Aye.
The motion passes.
All right, we'll proceed to item 3. We only have one item on our consent calendar today, and that's item number 3, in the matter of Dave Jones for Attorney General 2018. And with us, we have Acting Chief of Enforcement, Mr. Burton. Good morning.
Good morning, Chair and Commissioners.
Mr. Burton, any opening comments or background on this matter?
I don't have anything in particular to note on the stipulation, but I'd be happy to answer any questions that the Commission has.
All right, thank you. Do any commissioners have questions or comments on item 3? Commissioner Wood?
I just yet again want to thank you for what you wrote or what the staff wrote about public harm. I think, man, it's really helpful to see it spelled out like that. So I'm really grateful for what you did.
Great, thank you for your comments.
Commissioner Baker, any questions or comments?
Yes, thank you. I felt the same way, very well explained, and both the public harm and just the overall context, I appreciate that tremendously. I did have a question, and it's really for both my education and for the publics on something like this. It's on page 6, and it has to do with the factor of inadvertent neglect. And I saw 2 times mentioned at the bottom of page 6 after line 20, the sub-vendor information was reported as soon as it was received by the committee. And it's not often that STIPs come our way where the information that didn't get reported was reported as soon as it was provided. You know, this is a scenario where it sounds like it was a timing issue. And I'm maybe unfamiliar with how that happens, that they're found in violation for not reporting something that sounds like they didn't have the information. And I'm just curious if you could explain a little bit more how, I mean, the conclusion was that it was inadvertent or neglect. I almost wonder if it was just they didn't have the information because the STIP says it was reported as soon as they had it. Can you elaborate on that a little bit? Maybe not specific to this, but just how it happens that there's a violation when they don't have the information and they report it as soon as they get it. Really for my education. And thank you, colleagues, for bearing with my educational session here.
Sure, I appreciate your question. In this case, I don't have any other information about, I guess, the timing of how notification happened in terms of the major donor, or I'm sorry, the sub-vendor information. But, you know, as you see in the STIP, it was reported as soon as they got the information. And we're almost always going to view that as a mitigating factor that they timely file the amendments as soon as they get the information. But you know that does happen in enforcement cases, and you know we view it as mitigating. But in terms of this particular case, I just don't have any other information about you know whether they made outreach attempts or anything that had happened before that time.
So thank you. I appreciate that. The language that said in mitigation, that it doesn't say that in mitigation. So, but I understand that usually that's used as a mitigating factor. So do we have a scenario, a standard where if they make best efforts, it's not a violation, kind of like in the Behest setting that we've talked a little bit about, or does that not apply here in a setting like this?
I don't think that would apply here due to the sub-vendor information reporting requirements. It is a strict liability violation. And so, although again, it can be mitigating that they reported the information as soon as they had it, and maybe they didn't have it at the time the statement was due. Just following the letter of the law, it is a strict liability violation, and they are required to report that information timely on the relevant statement, just like they would any other activity, contributions, expenditures that are required on that statement.
Well, without negotiating future stipulations for the parties, that's a helpful part to have in something that could become a comparable, that especially as we weigh it as a mitigating factor as opposed to the way it's presented here, which is just a factor, that if they made a lot of efforts and somebody just didn't get them the information, and they do everything they possibly can. I can imagine a candidate saying, I've done everything I can. I've gotten all the information I can. And the second I got new information, I reported it, and I'm still getting hit. I wouldn't change the stipulation. I'm comfortable with the amount, a little on the high end, perhaps, given that this is something that looks like they reported as soon as they could. But I think it's very well written. It's reasonable. My request for my part is, if in the future there is information that they made best efforts and it is used as a mitigating factor, it'd be helpful to see it. So thank you.
Thank you.
Commissioner Wilson.
I want to thank Commissioner Baker for her question, kind of expanding on the continuing education. I have kind of a general question. I mean, it's more general in nature, but I know that the experience of a committee treasurer is taken into account. How does that generally impact the ultimate, decision on the, what kind of penalty will be issued?
Thank you for your question. We do look at the level of experience and sophistication, not just of the treasurer, but all the parties involved, the candidates, if there's a principal officer. And so we might look at it as mitigating if it's a first-time treasurer who does not have much experience. Sometimes the candidate will serve as their own treasurer and not have experience. We certainly look at that differently than the scenario where the treasurer is a professional treasurer who does this sort of thing full time. That's going to be viewed as more aggravating. They had an obligation to understand the act and because of their level of sophistication and experience. So that is taken into consideration.
Okay, thank you. And then I commend the executive director and the chief counsel and the entire IT operation for the information that's on our website, and included that on the website is I know there's some upcoming training that's scheduled for treasurers. Do you ever take into account whether a treasurer for a committee took training in the past, participated in workshops, or is that a variable at all?
Generally, I can't think of instances where we've looked at that, but I sounds like not a terrible idea. So
yeah, I'm not necessarily suggesting it's more of a question.
Sure. Yeah.
Okay.
I appreciate that. Thank you.
Just a couple of questions. One, to just clarify my understanding of the stipulation. The asserted fact that the committee reported the information on amended reports upon receiving it from the vendor, that was considered a mitigating factor for enforcement in this stipulation, right?
Yes, it was. Even though in that passage there is not particular language that says it's mitigating, we did consider it as mitigating.
And just to expound on that for continuing education of all the commissioners, is that all factors, when you talk about the factors, you're really talking about the things that are aggravating or mitigating that lead to a particular recommended penalty, right? So even if you don't say the words, that's the point of balancing those factors, right?
Yes, I would agree with that.
All right, thank you. The second question I have is, in this fact pattern that we have, again, taking it at face value, where a committee hadn't received timely information from a vendor, so they weren't able to comply with the requirements of the act. It struck me at first glance that this would be something that go through streamline. It's a relatively low public harm type case. But I noticed in the stipulation that the reason that couldn't occur here is because of a threshold in our regulations. So I just wonder if this came up again, but at a lower level, this is the type of case that would go through streamline on the ordinary, right?
Yes, this type of violation would qualify for streamline as a campaign reporting violation. The particular threshold for this case, because it was a state candidate, was $100,000, and the amount here was higher than that, and so they were excluded from the streamline regulations as they are currently stated.
Okay, great. Thank you, Mr. Burton. Any other commissioner questions or comments from Mr. Burton? Hearing and seeing none, do we have a motion? Okay.
I move the adoption of the consent calendar.
I'll second.
Is there any public comment on item 3? Hearing and seeing none, Ms. Linker.
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Madich.
Aye.
The motion passes.
Thank you, Mr. Burton.
Thank you.
Although don't go too far, because you're up next. All right, moving to our general items. Our first item is item 4, and this is an enforcement division update. Folks may recall a couple months ago, actually really throughout the last few months, commissioners have identified particular areas that they would like to receive additional information from enforcement on. And so this is an informational presentation by Mr. Burton and an opportunity for commissioners to ask questions. So Mr. Burton, take it away.
Thank you, Chair and Commissioners. Again, my name's Christopher Burton. I'm the Acting Chief of Enforcement. In January of this year, we provided a division update to you, which generated numerous questions, as the Chair had stated, and some requests for additional information. So today I'm happy to be here with you again to provide you with an Enforcement Division update. So there's a few topics that I will be covering today in particular. First, complaint and referral processing, Adwatch, our proactive pre-election outreach program, and then the impact of the statute of limitations on enforcement cases. And then finally, we'll be discussing our Behested payment case resolutions. So this first slide provides some additional information regarding enforcement's processing of complaints and referrals. Under Section 83.115 of the Act, enforcement has an obligation to respond to every sworn complaint, in particular, within 14 days. Enforcement must notify the complainant in writing what action is to be taken on the complaint, or provide a reason why additional time is needed to make a determination. We also provide this response to the subjects of the complaint as well. Our intake staff strives to present recommendations to the chief for approval for all sworn complaints within that 14 days. However, some complaints do require additional time to respond to. And there's a few common reasons why this may occur. These include complaints that require complex legal analysis, which at times requires the assistance of our intake attorneys. It's also common for respondents or their attorneys to request an extension of time to provide a response to the complaint, which takes us beyond that 14-day period, and we almost always honor those extension requests. At times, we also have to await information from filing officers, such as we've requested campaign statements or other filings. Sometimes it'll take some time to get those. And then also sometimes the sworn complainant will provide us with additional supplemental information after they've filed the complaint. And sometimes that occurs close to the end of that 14-day window, and so that we then need more time to analyze the complaint. As you can see on the slide, since the start of 2022, we have resolved about 64% of all sworn complaints within the 14 days. And so when I say resolved, that means we've made a decision on whether or not to reject the complaint or to open it into a case. And as you can see from the other categories, we do continue to prioritize sworn complaints over other types of complaints that come in, given their unique nature. And then finally, I just want to add that starting with this month's executive staff report, we have added some additional information in there. In particular, every month we're going to be reporting to you how many sworn complaints required more time to respond beyond that 14-day period. So I'd be happy to answer any questions that the commission has on this portion of the presentation.
Thank you, Mr. Burton. I have a couple of questions. The first is for the about a third of the sworn complaints that we don't process within the 14-day statutory timeline. You mentioned there are circumstances in which the respondents are asking for additional time, and there are other circumstances in which we feel like we need additional time. Do you have a sense of the breakdown of that? Is it about 50-50? Is it more them, us, more us than them? Do you have any gloss you can put on that?
I don't know if I have a good estimate on that. I think 50-50 I think would work. It's really a mix. But sometimes we get complaints that are a quicker review to get out in a faster fashion, but sometimes they require that complex legal analysis. And then if it is a more complex case, it's also going to be more common that the potential respondent or their attorneys need additional time to respond. But I think 50-50 would be a good estimate.
All right. In those circumstances where we are determining that we need additional time, we send a letter to the complainant and the respondent, I assume, letting them know that. Correct?
We do. We provide some sort of response within 14 days, whether it's the resolution of the case or the letter stating that we need more time and providing the reason for that.
Do we give, how much detail do we give in terms of why we feel like we need additional time? Do we just say we think we need more time and we'll get back to you? Or do we say we need more time to do X, Y, and Z?
Usually we at least give a little bit of detail, such as we need more time to await the response of the respondent, or we just generally need more time to analyze the complaint and come up with a resolution. The statute does state that we are supposed to give a reason, so we do always do that.
All right. And then with respect to the non-sworn complaints and referrals, neither of those categories has a fixed statutory deadline to respond, for us to respond in, correct?
Correct.
What's the average amount of time that we do respond to those types of intake matters in?
Well, as you can see in this chart, about 42% of non-sworns are resolved within 14 days, and the referrals are 34% within 14 days. In terms of average number, I don't have that at the moment. It is higher than sworn complaints because, of course, we prioritize sworn complaints. But I don't have a number for that at the moment. I'd be happy to get that for you.
All right. Do we have any internal guidelines or standards that, this is the target? You're not always going to make it. It's not a fixed across the board deadline, but just like, hey, for non-sworn and referrals, this is about the time period that we try to get them through the intake process in just as a matter of efficient practice.
Sure. I think the number one goal above all else is to prioritize the sworn complaints over other types. And I will say that going forward under the policy directive, which was passed by the commission in the recent reorganization of the enforcement division, that's a top priority for us to develop clear deadline-driven goals for complaint processing. Some of the shifting of duties that is happening along with the restructuring is going to free up more time and allow intake staff to focus even more of their workload on getting those sworn complaints resolved and the other complaints as well, and out the door as quick as possible.
So I take it then the answer is no, we don't have that type of target today, but we are going to look at those types of targets as part of the commission's policy directive in the future.
Yes, I would say that's correct.
All right. Thank you. Do other commissioners have any questions or comments for Mr. Burton on this slide? Commissioner Baker?
Thank you. I'm trying to make sure I show up in the picture with my hand raised. Thank you. Thank you for the report. And in follow-up to the chair's question, this may also have been part, if I'm remembering correctly, of the reorganization of the enforcement division, some of the policies we adopted earlier this year. But is one of those policies for the intake staff for certain matters that maybe one intake staff has done more of, they will get sent that intake? Or am I remembering correctly that it's kind of whoever's next on deck to get that matter? So if somebody's already looked at an issue, they may take less time, perhaps, than someone for whom that issue is new. Is that part of the reorganization? I know that is generally in enforcement, because we did talk about it in some detail, but I need a refresher if it's part of the intake process as well.
I think the biggest change with the reorganization is the addition of attorneys to the intake group. We now have one senior attorney and two junior attorneys. And the intake group already worked very collaboratively when they are evaluating their complaints. So even though a particular political reform consultant might be assigned a particular complaint, I know they're constantly collaborating with each other and seeking feedback for specific legal questions that come up. Attorneys have always been available to them to assist with complaint review, in particular, the more complex types of violations like conflict of interest. But now the scope of that is broadening now that we have attorneys who are actually part of the intake group to assist at a broader level with those complaints. And so really the collaboration is now including attorneys as well. And so even though the complaint might be assigned to a particular PRC, they are almost instantly reaching out to others for assistance if it's an issue that they know others have more experience with.
Great. That's great. They're not in silos, all separate from one another. So that's excellent. And two more quick ones, I think. Can you say a little bit more about, and I know you're kind of going by your gut feeling that maybe it's 50-50, as you referenced to the chair in response to his question, or what percentage, what the amount of time looks like for those cases that are beyond the 2-week process, the 14 days. For example, is it rare or a little bit common that it could be 2 months or 30 days? And maybe this is, when you come to your annual report, I know I'd be interested in these figures, but is there any more you can say about what the outer bounds and averages may look like beyond the 14-day period for those cases that need more time?
Sure, I appreciate that question as well. It really depends on the complaint in terms of the level of complexity and perhaps how long we wait for a response to come from a respondent. I would say if I had to put an outer bounds number on it, I would say we don't want anything to go further than 90 days. But certainly the majority of the complaints are resolved well before that time.
Okay. Resolved, like determined if they're coming in or if they're closed.
Correct. The resolution being a decision whether or not it'll be rejected or open into a case.
Gotcha. And I guess the final question is just if you could just say a little bit more about when you say we prioritize sworn complaints. The non-sworn complaints are also anonymous ones, if I'm remembering correctly, maybe possibly even whistleblower ones. But can you elaborate on what you mean by prioritize? Does that mean a sworn complaint is going to sit, a little bit, or is it just how it's allocated? Fill that in for us.
Sure. We prioritize sworn complaints because I think for two reasons. Number one, they have a particular statutory deadline attached to them. And even when we send out a needs more time letter, we still prioritize those because of that requirement. Number two, they're submitted under penalty of perjury with a complainant being identified. And so I think there's just generally a little more weight behind those. And so for that reason, we prioritize sworn complaints. Non-sworn complaints can be submitted anonymously or not anonymously. And so, of course, we try to resolve those as quickly as possible too, but we do generally prioritize sworn complaints due to their unique nature.
Well, thank you. I appreciate the information on this. And I know when we review this again, perhaps in a year or whatever the next time frame is, if we get a little bit more sense of what the range is looking like or the averages for after the 14 days, it's just helpful for us to have a better snapshot of it. But appreciate the report. Thank you.
Thank you.
Do you have a sense of the relative rejection rate between sworn versus non-sworn versus referral? Do we reject more non-sworn in referrals than sworn complaints? Do you have anything you can share on that point?
That's a great question. I can tell you that I recently looked at the rejection rate for sworn complaints, and I think since January of 2022, it was 60%. how that might compare to non-sworns and referrals. Unfortunately, I don't have a good sense of that at the moment, but I'm happy to get that for you.
I appreciate it. It just came to me during this discussion. And then the other thing I just wanted to ask about is Adwatch submissions. I know that's your next slide, but are those included in the category of non-sworn complaints or referrals, or are they part of sworn complaints? Or are they not? Or are they totally separate?
They are input into our complaint and case database system as non-sworn complaints.
Okay. All right. I just wanted to clarify that. All right. Thank you. Any other questions for Mr. Burton on his first slide? All right. Please continue, Mr. Burton.
Okay. Next, I'd like to present some more detailed information to you on our Adwatch program. The graph on this slide gives you a sense of what happens to the submissions we receive through Adwatch. So focusing on 2022, last year, I'll point out that we received 261 submissions through Adwatch, a number that's been reported to you before. So due to duplicates and other related submissions, those 261 submissions were consolidated into 171 complaints, which is how they're input into our case and complaint database system. And then of those 171 complaints, 70 of those, as you can see, were ultimately rejected, and 82 of them were opened into cases in 2022. As you can also see on the slide, the average number of days that it takes for enforcement to resolve an Adwatch submission at the intake stage is about 20 days. After that time, the submission is then either opened into a case or rejected. So during the intake stage, enforcement staff make efforts to bring respondents into compliance as to their advertisement disclaimer obligations prior to the election. Of course, with certain ad types, it's not possible to make corrections to the ads, such as with mailers or text messages that have already been disseminated. But for other ad types, especially electronic ads, it is generally easy to correct, and we do request that they come into compliance. So when surveyed, enforcement staff provided that their compliance outreach efforts generally do have a high rate of success where corrections are needed to the ads. And then I have a second slide here for Adwatch. This slide shows the different dispositions of our Adwatch cases. So after it goes through the intake stage and is converted into a case, we open a case. These are the different dispositions that happen at the conclusion of those cases. The time period for this graph, by the way, is also 2020 through 2022. As you can see, the majority of these matters end with a warning letter. Also, when looking at the specific type of advertisement disclaimer violation across these cases, the top three were electronic media ad display requirements, print ad display requirements, and mass mailing requirements. So those were the types of violations that we saw most prevalently during the last couple of years. With that, I'd be happy to answer any questions that you might have about Adwatch.
I had a logistical question about how Adwatch works, because oftentimes these are close in time to an election, right? And we're trying to get compliance before the election occurs for the benefit of the public. And so when something comes in through Adwatch that you determine has merit, and you start that process of reaching out to the respondent to gain compliance before the election, at that point in time, is there a case opened, or do you open the case later after compliance? Like, for example, after you've decided to issue a warning letter after receiving compliance?
We typically do not open the case right away. It stays in the intake stage while we focus on the compliance efforts, because in the pre-election stage, that's what's most important. Eventually, the Adwatch submission is reviewed by intake staff as any other complaint would be, and sometimes that happens after the election once the dust is settled and we've made our compliance efforts. Only after we decide to open it into a case would we then decide to resolve the case via a warning letter or however else we might take action.
but before that point in time, you've already determined that something isn't right and you're trying to gain compliance, right?
Yes, we have generally, yes.
So because these cases, and 20 days to resolve is your average time, right? I'm just trying to kind of tie it back to the other slide. The 42% of non-sworn in your chart, the first pie chart or the first graph that says it's beyond 14 days, that includes some of these Adwatch cases where we've just chosen not to open a case, but we know that there's merit to it and we're trying to resolve it. And so if we had opened a case earlier, that 42% would have been higher.
Sure.
Right.
Yes.
Okay.
Yeah, generally with the Adwatch, I think with the Adwatch submissions that have merit, because we have already done that analysis before the election, because we're moving quickly to try and get compliance, that would result in a quicker decision on whether or not to open the case, because we would have already done a lot of that analysis.
Yeah. So we're actually doing better than 20 days in a lot of cases, is my point, with the Adwatch submissions. We're moving these along very quickly.
Yes, we are.
Yeah. All right. Thank you, Mr. Burden. Other questions for Mr. Burden?
Yes, Mr. Chair, I had one. Thank you.
Mr. Baker?
This really goes to if some of the Adwatch questions complaints you're getting are about the substance of the ads, which are not our jurisdiction. Like, we don't determine if somebody's, being honest or distorting the truth. Does that, and I can imagine the public would want to complain about that, or somebody would, maybe opponents of each other. Does that even, if a complaint, I haven't tried the Adwatch app, but if a complaint were trying to say, hey, this isn't true, as opposed to the disclosures aren't correct, does it even upload in our system? And then those are ones that we would have to reject because they're outside they're not our purview. Or is it not possible at all that those even make it in the numbers?
That's a great question. Those submissions do make it in the numbers. There is no way to automatically reject them. There is a disclaimer on the Adwatch page, I think, that points out, what we don't have jurisdiction over, but sometimes that information, those submissions do still come through, and we do have to analyze them and review them just like we would any other complaint. And then ultimately, if they are of that nature where they're related to the content only, they would result in a rejection.
Okay. Do you have any sense, like, are they a extreme minority of the Adwatch cases, or they're notable, but they're not a huge number? You gave us what are the top three. Can you give any characterization of the quantity of this isn't true and I want you to do something about it complaints that hit Adwatch?
I don't know if it's a huge problem. We definitely get plenty of them. We get other types of Adwatch submissions that are also not under our jurisdiction. I think a pretty common one is allegations that a candidate-controlled committee did not put a disclaimer on yard signs or print ads, which do not require a disclaimer. I think there can be a misunderstanding there, but I think those are sort of maybe the top two types of submissions that we get that do not carry merit. But ultimately, as you can see on the last slide, we actually open complaints into cases more than 50% of the time with the Adwatches. Yeah, which means
thank you. I appreciate that.
Thank you.
Yeah, thank you.
Any other questions for Mr. Burton? Commissioner Wood, it looks like you're raising your hand, but your hand is
Yeah,
up.
I am. Oh, because you can only see the little one. I've got two versions of me, which is also very confusing because they're on a lag. So
That's awesome.
Yeah, I'll be in Sacramento next month, so I'm looking forward to seeing everybody in person again. This is Chief Burton. I'm really, really enjoying this because it's feeding my data brain very well. But I have a quick question related to this, which is you just were talking about something that feels so pragmatic, which is to try to get compliance before even opening a case, especially if we're in the time right before the election. That makes a ton of sense to me. But then just, we just looked at the STIP and we looked to see whether there's been past violations and things like that. And so I'm wondering how we treat these, like, so say I'm an incumbent and I have some Adwatch or some violation that comes through the Adwatch system, and my people bring it into compliance really quickly in, the 2020 election, and then I do it again in 2022 because there hasn't been a record of it because I was able to kind of get away with it. And I'm just wondering if there would be a prior record from the 2020 kind of blip of me coming into compliance quickly without it having been opened against me, and how we would treat that in 2022 if it were to actually rise to the level of something that would end up in a STIP. Does that make sense?
Yes, that's a great question. So the coming into compliance prior to the election, although mitigating, does not excuse the original violation. So if someone has a website up for a month without the disclaimer, and then they correct it maybe a couple weeks before the election, that's going to be mitigating, but it doesn't excuse the existing violation. And so, ultimately, we are going to resolve that matter in some fashion, whether it's perhaps a warning letter. So there would generally be a record of that prior history. Yes.
Okay, cool. Thank you very much.
Thank you.
Any other questions for Mr. Burton? All right, please continue.
Okay, next, I'd like to present some more detailed information about our other pre-election program, our proactive pre-election referral program, which generates campaign non-filer referrals in advance of each primary and general election. So these numbers, they've been presented before, but in 2020, we received 342 referrals across both elections, and in 2022, we had 385 referrals for both elections. Through the proactive program, again, we've provided this information before, but we do have a record of getting close to or at 100% compliance prior to each election. We also open enforcement cases for all proactive pre-election non-filers. As you can see, the trend has been to resolve more of these matters with warning letters, which stems from a policy that we instituted in 2022 that non-filers receive a warning letter so long as they filed their statements before the election. Also, the graph on the left side of the slide shows you the average lifespan of these cases that we open. And as you can see, that time has decreased significantly in 2022, thanks to a push to resolve these cases as soon as possible. So with that, I'd be happy to answer any questions you have about the proactive pre-election program.
Just to go back to slide 1, these pre-election referrals are part of the 34% category of referrals in your first chart, right?
Yes, they would be.
All right. And then just for the benefit of the public, who refers? You mentioned these are things that we proactively solicit and people make referrals to us. Who exactly is referring these things to us?
We solicit referrals from filing officers before every election. We have a list of them that we reach out to, and then they provide their referrals, and then we pursue them.
So county clerks, county filing officers.
Yes, exactly.
Filing officers.
Exactly.
Okay, good. All right, thank you.
Related question to that.
Yeah, go for it.
And this is just for, I think, the benefit of the public, and it's just kind of trivia, but roughly speaking, how many filing officers are there in the state?
Oh gosh, I don't know.
I mean, I can speculate.
Unfortunately, I don't know if maybe General Counsel Bainbridge or Executive Director West would have a better figure. No, they're shaking their heads no. So
yeah, but it would include school boards, municipalities, special districts.
It would include filing officers for those agencies as well. Yes,
Yes, a couple thousand at least, probably.
Perhaps. Yeah.
Yeah. Okay. Thank you.
Other questions for Mr. Burton on the pre-election referrals chart? Commissioner Baker?
Thank you. Yes, I mean, there's almost 1,000 school boards or school associations or districts in the state alone. If you just were to measure that one, then great point by Commissioner Wilson. My question is if the filing officers for state officials, are they included in the numbers that you're saying with filing officers? Because we're focusing on local, but if you're a state legislator or maybe a statewide officer, your filing is in a different place. Isn't that correct?
Yes, it is. Generally, those are filed with the Secretary of State's office. I don't believe we include. I don't believe those are included in the proactive pre-election program. Perhaps Executive Director West could correct me if I'm wrong on that.
No, that's correct. We reach out to all the counties and all cities over 100,000 people who have elections in that cycle.
It doesn't
I'm
mean
just
that.
curious why. Yeah, I mean, you can see where the next question is going. Why that sort of proactive part isn't as well, especially when we look at the kind of cases that we get and they file pre-election statements. What's the reason for that? Is it simply a statutory reason, or is there a policy basis for that?
So basically, this program was created, the chief before me, my predecessor, and it was created to assist local jurisdictions to getting compliance before the election. States officials are considered to have more resources and be able to do more outreach and get more compliance before the election. So this was a program that we instituted to really assist the local officials who may not have the resources or the heft behind them to get people to file before the election. And that was really the whole point of it, was just to get that 100% compliance in those local elections.
Okay, that makes total sense. So thank you. Thank you for that.
Questions for Mr. Burton? The only question I have, it's an observation, Mr. Burton, is the 2022 number of cases. I see we received 385 referrals in 2022. And when I add up the resolutions, it's like 220-ish, right? So there's 160-ish cases that aren't accounted for of those referrals. So does that mean those are still in the intake process today?
Some of them. So we don't necessarily open a single case for each single referral. In fact, I have the numbers here. So in 2022, we had 385 referrals. That resulted in 262 cases. So that number comes down. And 44 of those cases are still open and pending.
Okay, so there's only 44 left in intake at this point.
Correct.
Okay.
Yes.
All right. Any other questions for Mr. Burton? All right, please continue.
Okay. In January, we presented some information about enforcement cases that are closed due to expiration of the statute of limitations. This slide provides some more granular information about those cases. Of the 27 cases that we closed in this fashion between 2019 and 2023, as you can see, the top two reasons for such a resolution included deficient referrals and cases involving a low level of public harm and limited time to resolve. In particular, more than half of these cases resulted from the deficient SEI late filer referrals, in particular where the respondent had already left office at an earlier date, which was already outside the statute of limitations, and so therefore we simply closed the matter. Further, approximately 40% of this 27 cases were closed beyond the statute due to the low level of public harm of the violations, and for many of these, a short window of time to resolve the case. For example, these included a referral for a single non-filed SEI, a case involving a major donor campaign statement where the respondent was unresponsive, and a failure to file 2 24-hour reports. Those are 3 different examples. Many of these cases were also opened with little time to analyze and investigate the violations. For example, amongst this number, there was a case involving a 2014 violation that was opened in 2019, 2 cases involving 2014 violations that were opened in 2018, and a case involving violations occurring between 2011 and 2014 that was opened in 2018. As you can see on the slide, these cases represent a very small portion of our cases overall. And over time, we have seen less and less of these cases that fall into this category. However, we do continue to strive to get that number down to 0%. And thanks to a clear directive in place that all statutes of limitations are to be tracked in our case database system, we believe that goal is achievable. And finally, as discussed in January, enforcement typically seeks to toll the statute of limitations as it approaches, if necessary. This can be done either through the serving of a PC report, a probable cause report, or entering into a tolling agreement with the respondents. And so this slide also gives you some numbers for how many tolling agreements have been entered into in recent years. And with that, I'd be happy to answer any questions that you have about this slide.
Thank you, Mr. Burton. First, just an observation. My eyesight's bad, and so I just want everybody who's looking at this PowerPoint to take note. It's 0.8%, 0.2%, so we're talking about less than 1% of the cases in any given year, which is already, I think, an incredibly low percentage, and would be considered, in my mind, at least, to be an outlier. But I do appreciate your commitment and enforcement's commitment to get that to 0%. I think that's appropriate. But just for everyone's benefit, I wanted to frame it. We're talking about less than 1% of all the cases. So
yes,
just an observation. Other commissioners have questions or comments from Mr. Burton on this? Commissioner Baker?
Thank you. I'm very grateful for these data because it's one I've asked about for a while since some statute of limitations ran, and it is very notable, as the chair's made, just what a small percentage of cases they are that we are now tracking in the system statute of limitations to kind of keep anything from maybe slipping through that otherwise I'm sure the team would avoid having happen anyway. So I want to really thank you. I hope we'll continue to see these data and that they will get to 0 and that we can help you with that in every way possible through resources and otherwise. Couple questions. One thing you mentioned, you were talking about you said 40% of the ones that did expire, statute of limitations, and I may have not taken the notes correctly here, were in part due to a low level of harm. I just wanted to clarify, were you saying that they expired and they happened to be a low level of public harm, or that they expired because they were a low level of public harm, other things were more important and just couldn't get to it? I wonder if you can clarify that point.
Sure, that's a great question. I think with these cases, in addition to the fact that they came in so close to the statute of limitations, yes, these also just serve as instances where, due to the nature of the violations and balancing staff resources with the public harm, these cases might have been deprioritized so that we could focus on other cases that carried a higher level of public harm. One scenario that could occur is that we approach the statute of limitations for a case that involves violations with a low level of public harm, and we are unable to get a tolling agreement, and so our only option is to take the time, which can be significant, to prepare and serve a probable cause report. And so, when on balance, for some of those cases, we would choose to focus on the other cases that carry a higher degree of public harm. So I think that, combined with the short turnaround time, is why we see, it's a low number, but we do see some cases that fall into that category.
Mm-hmm. And if I may, in follow up, so is another option, and if you can characterize how much time that takes in comparison to probable cause filing, be a warning letter? Because I would imagine a warning letter, you want to do the research and know where you're at to have an appropriate warning letter. Can you explain if that is an additional option, if it takes just as much time or if it's not appropriate?
A warning letter could be considered, and I think going forward, that's something that we would certainly look at. But either way, we would still need to take the time to review, either at the intake stage or investigate, if necessary, the underlying violations to confirm that they have merit.
Mhm. Well, thank you. These data really are very helpful to have. I hope we'll get to see them in each, at least annual report from the team, and that number will continue to go down. As I said, that we as commissioners are doing our part to assist in that. I do remember from, I think it was the first enforcement report in my time sitting as a commissioner, where one of the statutes that had run, it didn't seem like it was a low public harm. The individual did get a warning letter. It was mentioned that it was because of COVID. We had COVID issues and we had a shortage of staff. I hope if those kind of things come up again, that we can just find a way to help you triage and deal with them. So bring them our way even before the annual review or update if that happens. Thank you for the time on this.
Thank you.
Any other questions for Mr. Burton on statute of limitations? Bless you. All right, hearing and seeing none, please continue, Mr. Burton.
Okay, and then finally, as requested, this last slide provides some information regarding our behested payment cases and how they have been resolved in recent years in light of the addition of these violations to the Streamline program. As you can see, since behested payment violations were added to Streamline, which was in 2021, we have seen a higher number of warning letters issued for these types of cases. And we also have 10 total behested payment cases that are currently open with the Enforcement Division. So that's all I have for this category. I'd be happy to answer any questions that you have about the behested payment cases.
Thank you, Mr. Burton. Question for you. Do you happen to know the rejection rate, the average rejection rate of complaints involving behested payments?
I unfortunately do not have that number, but I'm happy to get that for you.
All right. And do you have any information on how many behested payment complaints are currently in intake?
I don't have that figure either, but I'd be happy to get that for you.
Part of the reason I'm asking is I was struck by how few behested payment cases there are that come to the commission. At times there's a lot of attention paid to this in the news media, etc. And I'm just looking, cases opened in 2022. There are almost 1,000 cases opened. We receive, almost 3,000 various types of complaints and referrals in a year. And you're looking at like 10 cases, some years less than that, in other years. It just seems like, is it a fair observation that this is a very small part, at least recently, of the commission's workload in enforcement?
Yes, it is. I've had that same observation that the numbers do seem low. I don't know if I have a explanation for that. I'd have to speculate, but I would agree that the number does seem low.
Okay, thank you. I appreciate that. Other questions for Mr. Burton on the behested payments information?
Just a general question. Yeah, Mr. Burton, thank you for the detailed report. In terms of the behested cases, is there any, just general, not exact, how long it takes to resolve those cases once there's been a complaint filed?
Sure, I don't have the particular figures on
It's
that.
just general.
Yeah, I think generally a behested payment case could be resolved quicker because I think a lot of times you see the respondents have already filed the amendments, which kind of helps us track what was filed late. And so I think there are certainly some behested payment cases which are a little more straightforward and quicker to resolve.
All right, thank you.
You're welcome.
Other questions? Commissioner Wood?
I feel like maybe I spaced out or something, but the closed with no action category, is that not the rejected cases? That's a separate category, something that was kind of considered and researched and then closed?
It would be the latter. It would have already been opened into a case, and then we found that there were actually no violations. So I think when the terminology rejected is typically used, it's referring to what happened at the complaint stage.
Gotcha. Thank you.
You're welcome.
Commissioner Baker?
Thank you. And I was just going to focus down on the advisory category. Can you just clarify, since it pops up once? I mean, 2021 looks like a bit of an outlier year. Also, on the sheer amount of warning letters, perhaps that was just a matter of the volume. It wasn't. Was that I don't think that was an election year. It was a recall year. I'm not sure what about 2021 happened that made it such a blip. But I wanted to ask you if you could characterize that at all. And secondly, can you explain more what advisory is, since it only kind of looks into one time period, 1 year, and doesn't pop up on the other screens or categories, years?
Sure, those are great questions. The reason the numbers are higher in 2021 is because in the interest of fairness, knowing that behested payment cases were going to be added to Streamline, at the time, enforcement had held back on some cases to await the passage of Streamline. And then once that occurred, maybe a batch of cases were resolved close in time together. That's why you see a higher number there. An advisory letter is an enforcement resolution where we don't believe we have sufficient evidence to show a violation, but we think it would be helpful to provide information to the respondent to help them comply going forward. So that would be more appropriate for someone who is currently in office. So advisory letter is a no action closure letter, but just with a little more information provided to educate the respondent going forward.
And is there any particular reason why that is not something that appears? I mean, there's quite a few of them. There were 7. Was it a policy decision that year, and both before and since it just hasn't been the standard, or maybe just the cases where that's appropriate haven't popped up?
Yeah, I don't have a particular response to that, but perhaps Executive Director West might, as she was the enforcement chief around that time.
Guilty as charged. So yes, it was actually a policy decision at the time, as Mr. Burton alluded to. As the commission worked through the Streamline regulations, which included also the criteria for warning letter, we wanted to make sure that we held some cases in order to treat them all the way the commission direction was given. So advisory letters were also used at this time, because anytime there's a new regulation in place, we want to give advisory letters and warning letters to try to get everybody into compliance and say, here's what the rules are. We want you to understand them. And so they are used more during a time of transition.
Mm-hmm. Thank you. That's a very helpful explanation. I note the small number of behest payments compared to everything else we do. I just think it is because so many people still don't realize when they're subject to it. And it's kind of proving a negative. It's a little bit different in some ways than some of the other filings we have, but that's all speculation. And regardless, thank you for your work on this.
Thank you.
Any other comments for Mr. Burton on the behested payment slide? All right. Any other comments for Mr. Burton on any portion of his presentation before we open it up to public comment?
I just want to make one.
Yeah, go
Just
ahead.
want to, thank you for the detailed work, and I know it took countless hours to put this together with your, with your team. So thank you.
Thank you. I appreciate that.
All right. Any public comment on item 4, our enforcement division update? Hearing and seeing none. Mr. Burton, I'll echo Commissioner Wilson's comments. Thank you very much. Great presentation. Appreciate the time and effort that you put into it.
Thank you so much.
All right, take care. All right, let's go ahead and move on to item 5. This is pre-notice discussion of amendments to regulation 18361.1. And with us is Senior Counsel John Fazer. Morning, Mr. Fazer.
Good morning, Chairman, Commissioners. My name is John Fazer with the Legal Division. I'm here to present amendments to Regulation 18361.1 regarding administrative subpoenas. The existing Regulation 18361.1 requires Commission staff to make reasonable efforts to obtain information voluntarily before issuing an administrative subpoena. The Executive Director has the discretion to forego this procedure for an investigation in progress. Staff is required to periodically report on the status of all investigations to the Commission members. including the reasons for issuance of any administrative subpoena, without first making reasonable efforts to obtain the information voluntarily. The existing regulation also states that failure to do so does not affect the validity of any administrative subpoena. The proposed amendments, which were prepared in consultation with the Enforcement Division, would provide an objective standard for what currently constitutes reasonable efforts under the existing regulation. Under this new standard, Commission staff would not be permitted to serve an administrative subpoena sooner than 21 days after making a written request for the voluntary disclosure of information from a prospective subpoena recipient. These proposed amendments would replace the existing subjective requirement that staff make reasonable efforts to obtain voluntary disclosure, and would also remove the requirement that the Commission oversee this process with a clear objective definition of what constitutes reasonable efforts. The subjective requirement would eliminate any confusion and undue delay caused by attempts to comply with an undefined subjective requirement, make it easier for potential subpoena recipients and their counsel to understand and follow, and provide a clearly defined time frame that would promote and facilitate compliance with staff's efforts to obtain voluntary disclosure. That summarizes the proposed amendments to Regulation 18361.1. I would be happy to discuss any questions or comments you may have.
Thank you, Mr. Fazer. Any commissioners have questions or comments for Mr. Fazer? Commissioner Wood?
Yeah, this is mostly for the purposes of the administrative record. I'm just wondering if you could discuss other timeframes that were considered and rejected here. There's really no discussion of how we landed on this particular timeframe.
Correct. In consultation with the Enforcement Division, they discussed internally with their investigators to determine how much time it was taking to obtain voluntary disclosure. And the time frame was between 2 and 4 weeks. And we landed on 21 days as a fair number. And it's actually sort of, I guess, mirrors the requirement of subpoena response in the first place. So 21 days was not arbitrarily determined. It was based on internal discussion, particularly with enforcement who handles these.
Thank you. That is perfect and exactly what I wanted to hear. Thank you so much.
Thanks, Commissioner.
Nice making of the administrative record there.
I'm teaching administrative law this semester and just wanted to make sure we had it in there. Thank you.
There you go. Thank you. Commissioner Wilson?
Commissioner Wood is much more informed on this issue, but I had a similar question regarding the 21 days, and you've addressed that. But I have a kind of similar question, and that is, let's say there's a need to expedite the process, and the Enforcement Division has realized, wait a minute, we need to issue a subpoena sooner than 21 days. And I did look at the regulation, but you're the expert here. What options exist to expedite the process if there's a need to issue a subpoena sooner than 21 days?
A good question. The proposed amendments would not include any modification of the provision for the executive director to have the discretion to forego the procedure with an investigation in progress. So under those circumstances, there could be various circumstances that apply there. So for instance, where the recipient of the subpoena requests that you serve a subpoena, there's really no need for this voluntary disclosure process. In those instances, we'd still have the discretion of the executive director to proceed on his or her discretion.
So in consultation with the executive director, a subpoena could be issued in 6 days if there was a need to expedite the process.
Correct.
Okay. All right. I'm still not sold on the 21 days, but that's not an issue that I'm gonna raise. But thank you. Okay.
Great. Any other questions or comments for Mr. Fazer on this proposed regulation? Hearing and seeing none. Is there any public comment on item 5? This is our pre-notice discussion of proposed amendments to Regulation 18361.1, Administrative Subpoena Procedure. Hearing and seeing none. Thank you, Mr. Fazer. Good presentation. The change is pretty straightforward, and so we'll see you back in June.
Very good. Thank you.
All right, thank you. All right, moving right along, we'll move to item 6. And this is another pre-notice discussion. This to amendments to regulations implementing Senate Bill 1360, disclosure in advertisements. And with us is Senior Commission Counsel Erica Boyd. Good morning, Ms. Boyd.
Good morning, Chair and Commissioners. Erica Boyd with the Legal Division. Today we have the pre-notice discussion of proposed amendments to a few of the regulations covering advertisement disclosures. As mentioned, these are due to changes made by SB 1360 in 2022 to the Disclose Act portion of the statute. Today we're proposing minor changes, largely correcting cross-references, but there are a few substantive changes as well. So to begin, in section 84502, certain advertisements have to include the words "ad paid for by," followed by the full name of the committee as it's found on the statement of organization that's filed with the Secretary of State. New subdivision E was added to this section, allowing for a shortened committee name in specific instances. So the proposed amendments today are to regulations 18402 and 18450.6, just adding a reference to this section where a shortened committee name would be allowed. To clarify, this substantive change to the naming requirement is actually found in the statute. What we're amending to the regulation is merely a reference to the allowable form of the committee name. So the change to the statute allows a shortened committee name in 4 types of advertisements. Those are video advertisements disseminated over the internet, print advertisements larger than those designed to be individually distributed, so yard signs, billboards, and these are ones paid for by a committee other than a candidate, committee, or political party, and electronic media advertisements paid for by a committee other than candidate or political party, and text messages. So I have a couple examples. If IT could help with the slides, the first one there. Thank you. Bear with me. All right. So the statute specifically allows for the name shortening by either of the following. The first being displaying only enough of the first part of the committee name to uniquely identify the committee, or if paid for by a committee with top contributors, you can include the committee ID followed by the number in the top contributors. So to have a couple examples, say the full committee name is Yes on 99, Californians for a Better Tomorrow, a coalition of small businesses, employee unions, and nonprofit organizations sponsored by Acme Corporation. So in the first instance, you can sponsor it. For a committee with sponsors but no top contributors, the sponsor name must still be included in the committee name for the disclosure. So you could have Yes on 99, Californians for a Better Tomorrow, sponsored by Acme Corporation. Alternatively, for a committee with a sponsor who is also a top contributor, so long as the name is listed as a top funder, then they don't have to also be listed as a sponsor. So in this one, you see it's a bit different. Yes on 99, Californians for a Better Tomorrow, add committee's top funder, Acme Corporation. So in that instance, Acme Corporation is both a sponsor and a top contributor. They'll only need to be listed once. And then the last option there is for a committee that has top contributors. They can go ahead and use just the words committee ID followed by the ID number as provided by the Secretary of State, and then list the committee's top funders, so in this case, Acme Corporation and Employee Union. This is a new change to the statute. Previously, a committee name had to be included in its entirety on all disclosures. So we know that there are going to be questions that come up about this as people start to put this into practice. We, at this time, want to see what types of questions we're getting to both formal and informal advice and decide from there if we need to do a further regulation to help clarify what would be permitted, what still needs to be included. But we have this is on the radar. We know it's going to be something to keep an eye on coming up, but at this time we want to wait and see kind of what questions specifically arise. That's the first change.
All right, any questions on Ms. Boyd's first slide? Hearing and seeing none, please continue.
Okay. So the second change in section 84503 requires disclosures of top contributors in specified instances. Just to refresh, top contributors are those top 3 of $50,000 or more. So a contributor that has done less than $50,000 in the aggregate is never going to have to be listed as a top contributor on an ad disclosure. Previously, this subdivision B specified that a name need not include such terms as incorporated, committee, political action committee, or corporation, unless the term was part of the name in common usage or parlance. That language has now been revised to shall not include. So Regulation 18450.3 currently requires a major donor top contributor to be listed by their name of filer on their most recent campaign statement. So the proposed amendment to the regulation merely specifies that the terms incorporated, corporation, political action. Click. Yes. There you go. Not be used in accordance with 84503B. So again, the substantive change here is to the statute and what is required to be disclosed, and we are updating the reference in the regulation. So looking at this slide for a couple examples, these are purely examples. I picked these names because they're common enough that people will know them. I'm not saying these people have committees or that they've engaged in political activities. It's just an example. So say Google Inc. was the name of the filer on their major donor filing. That is not the name in common usage or parlance. People know it as Google. So on the disclosure, you would list that contributor as Google. Alternatively, the Corporation for Public Broadcasting is known as the Corporation for Public Broadcasting. So in that instance, you would retain use of the word corporation when listing the top contributor. Again, this is an area where we know questions are going to be coming up as people actually put this into practice. This is a change from what's been done previously, so we will keep an eye on it, see what questions we're getting to informal and formal advice, and then further advice from there as necessary.
So the phrase common usage or parlance, that's a new statute. That is new language that the legislature put in the statute that we're implementing in part through these regulations. It
was previously in the statute. The change is previously it said need not include, so it wasn't a mandatory. Now it says shall not include.
And do you know, have we ever advised what that phrase means and like just how we're going to interpret it? Because the example you said everybody knows Google, right?
Right.
And I think that's fair enough, right? Corporation for Public Broadcasting, all right, fair enough. But there's going to be all these things in the middle. So what's our standard going to be? How are we going to approach that?
To my knowledge, we have not advised on common usage or parlance. I don't think so, just because I think it was permissive before, so people could decide whether they wanted to keep it there or not, and we're likely going with the name that someone's known by so there wouldn't be confusion. This will bring up some questions. I think that, we're kind of waiting to see before we put draft pen to paper and maybe put in place something that isn't actually necessary. So we want to see what kind of questions are coming up and then kind of go from there.
That makes sense. Thank you. Commissioner Wilson.
Yep. Kind of a related question, and thank you, Council Boyd, for your presentation. And I think most people do know what Google is, but Corporation for Public Broadcasting, if it was abbreviated CPB, most people wouldn't necessarily know what that is.
Right.
But the example that I think of, and I hate to admit that I didn't initially know what STEM meant when I first saw that, several years ago, but that's an abbreviation. So how do you how would we make the determination of what is an abbreviation that is commonly known versus one that has to be spelled out?
I think previously the statute refers to needing to use what's on file with either their statement of organization with the Secretary of State or on their last campaign filing. So if an entity is filing as STEM Incorporated, that is what they can use as the top contributor name, whether or not someone knows in common usage or parlance what exactly STEM stands for. Here, you're right, this is going to bring up kind of some questions of interpretation as to what needs to be included and what can be left out that people will commonly understand.
All right, thank you.
Sure.
All right. Commissioner Wood.
Thank you for this presentation. I briefly went back and read the act that made these amendments, and they seemed to be concerned about, names that are meaningless, basically, and that don't give much public information. They were very interested in having more public information, at least when they talked about their statutory purpose. So I would assume that this is about kind of readability and making things kind of simple to understand, what I'm guessing is lurking in the minds of the enforcement people is, are we really gonna go after Acme Inc. for putting the word Inc., which is really just, in that case, would be additional information, although the information isn't all that helpful. And so I know that we're many, many steps from an enforcement action on including comma Inc. But I would hope that because we're all interested in information here and like making sure the public gets information, that we would kind of exercise our enforcement discretion wisely when it comes to things like this.
I think
maybe it's too premature to even talk about that now, but it just seems to me that this puts enforcement in a really awkward position with some cases.
Right, definitely something to keep in mind. I think as Executive Director West said earlier, that we take a more of an advisory stance when the law is making a substantive change that people might not be used to. And so this will be, very different than just listing a top contributor as it's listed on its last campaign statement. So I think that we'll be cognizant both on the legal and enforcement side of that might, take a while for people to really get used to. Very good point.
I mean, I don't disagree with what we're doing here. It sounds like this is a change we have to make because of the change in the statutory language. It just feels really awkward for enforcement to me.
Yeah. Thanks, Commissioner Wood. Commissioner Baker?
Thank you. Also appreciate the presentation and the last point by Commissioner Wood that we have to make it. It's the statute that's there. My two questions are, if common usage in parlance is anywhere else anywhere in California law that might give some guidance, as opposed to just, I'm sure your team has already looked at that and would in the case of complaints or advice opinions out there, but maybe it's been used somewhere and it's been filled in. And the same for other states. I'll put a lot of legal research on your deck, but if there's anywhere else that other states have maybe used some language like this within the umbrella of what our agency does, I honestly don't know, but I point you in that direction as one possibility, just to see if it can be helpful to us in filling in the regulations. So that's a suggestion. The second one is it actually came from Commissioner Wilson's point about STEM. I'm sure the team looking at these regulations is already aware that people might get cute with their abbreviations. STEM could sound like hey, this is great. It's education. It's all this. But if you name your committee with the right capitalized points that you can call you STEM, and you have nothing to do with it to sort of give a different impression to the electorate. Maybe I'm being too much of a very cynical and conspiracy theorist, but I just invite you and the team to keep that in mind as we start to wade through these regulations and what we might do. And that may not come until we see cases and advice and complaints, but know that people can be cute with their titles to try to abuse rules. Thank you.
Will do. And one point on that, just to let you know, I think we see the abbreviations much more in terms of major donor committees and, perhaps what their corporate name is that they're using on the filing, as opposed to a ballot measure committee. There are very specific naming rules for that. We had a fact sheet last year, right? Or the year before about the naming requirements. So a ballot measure committee is always going to have the name of the measure, the number, yes or no. So at base, there will be those requirements for the other political action committees that they have to have that information in a name. So they won't be able to just have STEM for yes on 34 or something like that. It'll have to be more specific. But we will, yes, good to keep an eye on, because this is definitely a way that a name could be shortened inappropriately.
Thank you. Go ahead and continue, Ms.
Okay.
Boyd.
So the next change is to section 84504.1. It currently requires advertisements paid for by a committee other than a candidate-controlled election committee or political party committee to include top contributors as necessary when the advertisement is a video. Currently, contributors have to be listed on separate horizontal lines. The new subdivision B4 specifies that in addition to these separate lines, if the name of one or more top contributors exceeds the width of the screen and is required to wrap around, then the name shall be clearly marked using a highly visible symbol or minimum vertical separation as defined by the commission. So we have added to Regulation 18450.4 that names can be delineated using one or both of the following: either a common grammatical symbol, such as a comma or a semicolon, or sufficient vertical separation such that the text is easily legible. So on the left-hand side there, you see a listing of 3 different top contributors kind of running together. It might not be easy to see, clearly delineate between them. On the right-hand side are 2 separate examples of what you could do based on the language in the regulation. Now, the first example uses semicolons to separate these, and we didn't want to just specify, can only be done by a comma, so that if somebody uses a semicolon, that would be it. And already they'd be in violation, and that might be an issue for enforcement. So we went with the common grammatical symbol in that instance, or you can have sufficient vertical separation between them so that someone can easily see these are different contributors. And people can use either or both based on the current statutory language.
Any questions or comments from Ms. Boyd on this slide?
Okay.
All right, please continue.
All right. There was amendments to section 84504.3 regarding electronic media advertisements that changed the subdivision lettering. So this is requiring non-substantive cross-reference amendments to 18450.4B, 18450.8A, and 18450.9A. These are noted on the drafts, but if you have any questions on those, I can go through each of them.
Any questions for Ms. Boyd on that portion? All right, please continue.
And then for on 18450.9, as it was posted online, we were proposing to take out a portion regarding electronic media advertisements paid for by committees but posted by third parties. Since posting this material, we've spoken more with the sponsor of the bill, and there's a question as to whether there was really an intent for the current language to cover posts by third parties. So in an abundance of caution, we would like to go ahead and leave the language as it currently stands so that we do have a requirement for disclosure on these types of posts. We're going to have further conversations with the sponsor, and also parallel to this is the commission-sponsored bill, SB 678, is moving through the legislature, where it would require specific language by third parties posting political advertisements. So it might address this issue as well. This is all to say, we will circle back on that point. It is being addressed, but for right now, we'd like to go ahead and leave the language in subdivision B.
All right. Any questions for Ms. Boyd on that portion? Yeah, go for it.
Council Boyd, in terms of the proposed regulations that implement what Senate Bill with 1360, you could have an actual link that took you to all the detailed information you would need to comply with the statute, correct? Right. Okay.
Yes.
I just want to say that for the record. I know that you know that, but it's it's kind of buried in a lot of the information that's out there. So it's pretty easy using a hyperlink to display whatever information needs to be displayed to comply with the regulation as well as the statute.
Yes.
Okay, thank you.
Sure.
All right. Anything further,
Okay.
Ms. Boyd?
Yes.
All right.
So moving to our connected television. As you know, many are now viewing political advertisements over programming through streaming TV. So if people are watching TV programming through streaming TV or through connected TV, political ads are coming up just as they would if you were watching on a regular television. So as outlined in the memo, these services are sometimes referred to as over the top. It's a means of providing television and film content over the internet. OTT implies that it's a content provider going over the top of traditional broadcast services such as cable or network programming. So the OTT refers to the platforms that deliver this type of content. So you're looking at Amazon Prime, Disney Plus, Hulu, Netflix. Connected TV then is a subset of OTT, and then it allows users to view the content via a smart TV or other connected device, such as Roku or gaming consoles like Nintendo Switch or Xbox. So content viewed via these platforms, however, is akin to watching a show on a network or a cable broadcast in that the appearance for the viewer is largely the same. The advertisement comes up during the show. You can't fast forward through the ad. There's limited ability to interact with the screen as the same as you would with, say, a web ad that's popping up when you're scrolling through Instagram or Facebook. So television is currently undefined in the Act and regulations, such that we're proposing adding a definition to 18450.4, clarifying the ads viewed via OTT delivery or CTV device require the same disclaimers as traditional television advertisements. Are there any questions on that one?
Any questions for Ms. Boyd on that portion of the reg package? All right, please continue.
Okay. Last one, in 18450.8B, staff noted that there's an unnecessary cross-reference there, so we wanted to remove that in the interest of making it as streamlined as possible.
All right. Thank you, Ms. Boyd. Any final questions, comments for Ms. Boyd? Hearing and seeing none. Again, reminding everyone that this is a pre-notice discussion. Regulations implementing Senate Bill 1360, disclosure and advertisements. I'll call for public comment. Is there any public comment on this item? This is item 6. Hearing and seeing none. Thank you, Ms. Boyd, and we will see you in June for adoption. All right, thank you. Commissioners, I'd like to propose a 5-minute rest break. We've been going almost 2 hours. Anybody object to that? All right, let's go ahead and reconvene at 11:40 then. All right, thanks guys. we get going from our break. We are on item 7, it's collections procedures. And here to present for us are Executive Director Galena West and Commission Counsel Valerie Nudie. Still morning. Good morning, Ms. Nudie.
I'm turning on my microphone and waiting for the slides to be up, and then we can get started. I can give a little bit of an intro while we're waiting for the slides. Executive Director West and I prepared this presentation to help illustrate the Commission's collection procedures, as well as provide the Commission with information on some of the numbers facing the collections program and where we plan to go from here. This presentation focuses primarily on our internal processes, the FPPC's processes, and proposed future actions. But before I get there, I'd like to provide some brief background on the expectation of the state generally as far as collections processes go. In general, state agencies are required to provide ongoing accounts receivable training to staff to ensure proper record keeping and to keep up to date a collections procedure that is in accordance with the law and best practices, and that will assure prompt follow-up with accounts receivables due to the state. When the Commission approves an imposition of a fine in an enforcement case, any unpaid portion of that fine becomes an account receivable payable to the California State General Fund. So all of this is to say that the purpose of our collection program is to collect fines in order to both achieve compliance and deter non-compliance with the Political Reform Act, but also to collect debts due to the state of California. So with that, I'll start our actual process as it stands currently. Trying to use the clicker. There we go. So this is a very general depiction of how the collections process moves through the agency. I'm going to get into all of these points further in more detail further on in the presentation.
Hang on, Ms. Nudie. I just learned that we're having technical difficulties with our live stream, so let's pause for just a second.
We can do that.
Welcome to AT&T's teleconference service. Please enter your access code, followed by the pound sign. To join the conference as the host, press star. Otherwise, please enter your host password, followed by the pound sign. There are 1 participants on the call, including you. You are joining your conference as the host.
All right, I've gotten the green light.
From the
Nudie?
top or from where we're at?
From the IT folks, they're the important ones right now. So,
Okay.
go.
So, like I said, this is a very general depiction of how the collections process moves throughout the agency. I'm going to go into more detail on each of these points as we move forward in the presentation. But essentially, the case starts with enforcement. And once enforcement has acquired a judgment and they've attempted to make all the contact they can with the person who owes the debt, it is transferred to administration. At that point, administration will work with legal to continue to try to collect that debt, to reach out to the debtor. And when it's time for renewal, which happens every 10 years, administration and legal will work together to renew the judgments as well. So I'm going to continue on to the criteria that enforcement must meet to transfer the case to admin. Now I know there are a lot of words on this slide, and I'm not going to sit here and read them all to you verbatim, but what I wanted to do was give a visual representation of the list of things that should happen before the case is transferred. The gist is that once we have an order from the Commission, enforcement will try to collect the debt first. If that's not happening, they will procure a judgment from the Superior Court of Sacramento that allows us to take further steps to enforce the judgment. They will send a first letter of demand. Enforcement will also run a skip trace, and you'll hear that term a couple times in this presentation. What a skip trace is a tool that our investigators have to get the most accurate address that we have accessible to us for the debtor, and any other information that we can glean about how to contact them. At that point, once they've run the skip trace and sent out the letter, and they're not trying to contact the debtor any longer, they will transfer the case to admin. Something to keep in mind is that these are cases that are in default. By the time they get sent to admin, we have already made attempts to contact and collect on the debt. So that's the posture of the cases, so to say, at the time that they make it to admin. So what happens when admin gets the case? Admin will send a second demand letter 30 days after the first letter sent by enforcement. They will, of course, use the most updated information we have from that skip trace, and they will send a third demand letter 30 days after the second. If the debtor is amenable to trying to work through their debt, staff will offer all reasonable opportunity they can to voluntarily pay the debt. And if not, as our letters move on, they will get progressively more serious, might be the best word to use, in letting the debtor know that further actions can be taken in the collections process to obtain the amount that they owe.
Can I ask you a quick question?
Yes.
When you say staff offers all reasonable opportunity to voluntarily pay, do they offer like payment plans? Is that
They
what you're talking
do,
about?
yes.
Okay.
And there are some requirements in that. They have to be in writing. They discuss with the debtor terms such as, are there, is there a grace period or is there not for a late payment, what the payments are going to be, and the delineated plan.
Okay.
Mm-hmm.
Right.
And
Same. Yeah.
And there's a future regulation that the executive director will discuss as well moving forward that might give us some more ability to work with debtors in the future. So the other thing that admin, or the other step of the process, I should say, that admin and legal work together to acquire are renewal of judgments. And the reason that we do that, well, I apologize, I skipped a step. We do this every 10 years. Otherwise, the judgments will lapse. And the reason that we want to keep them active is it allows us to formally impose interest for the 10 years that the case has not been paid. It gets it in the court system with the updated interest. And it also allows us to keep all of our rights to continue collecting the debt. How it works is it's pretty formulaic. Admin will reach out to an investigator and get an updated skip trace. And that lets us give the proper notice, right? We have to give notice that we're renewing this judgment. Then they will prepare the renewal paperwork, which is a Superior Court form. It's got blanks, and we essentially fill in with our information, the debtors, and a calculation of the original fine, any payments made, and the interest. And we get the interest from a calculator that the San Diego Superior Court created, and it's really helpful because you can put in what payments have been made and the interest and the amount, and it just clicks out a number for you, which is really great. The interest is 10%. And so by the time we're getting to the 10-year, it doubles the fines, essentially.
Quick question, is that 10%? Is that 10% annually or 10% total?
Annually, I believe. Right, yeah, yes. Yeah, it like I said, by the time we're getting to that renewal, if you look at the fines, they end up essentially doubling. So once admin has done all of the back work on getting the forms created, getting the interest calculation, they will send it to an attorney in legal, which is myself currently. And we do a review and make sure that everything looks accurate. Everything, everyone can make typos. Everything is accurate. We sign it off, and admin will file the renewal with the Superior Court, and we'll get confirmation that it has processed and our judgment is good for another 10 years. The next slides are going into numbers and breaking down some of our cases in a way that hopefully is helpful in understanding what the collections looks like. So I'd like to stop here in case there are questions on the current process. It's going to shift a little bit moving forward. So
I just have one quick question. The renewal of judgment, like in terms of staff time for a particular case, like how much time does that take, that process for a staff member to do?
I'll start with myself because I know specifically how long that takes. generally speaking, it doesn't take me more than a day, because and that's sending emails back and forth and waiting for responses if there are things that need to be fixed. If everything is correct and ready to go, it takes me about 15 minutes. It's pretty quick to sign the paperwork and check everything. And I think for admin, it takes a little bit longer because they have to collect the information and they have to reach out to the investigator and take some time waiting. But I don't think it is a huge detraction from your overall day-to-day, in the sense that a lot of it is kind of sitting and waiting. I asked the investigator, now I'm going to wait. I sent it to the attorney, now I'm going to wait. And they do have to go physically file it in court, though, so that takes some time, I'm sure, and requires them to be physically present, and so it takes some scheduling.
All right. Appreciate that.
Mm-hmm.
Other commissioners have questions for Ms. Nudin at this point in her presentation.
Okay.
Please continue.
Then we are going to start getting into some of the numbers. We have 99 cases total in collections right now, and I took them and broke them down by how much each debtor owes, and I separated them into categories. And so here, the bulk of what people owe are either in the $5,000 to $10,000 range or the $10,000 to $20,000 range. That tends to be the most common. There are some outliers, as I'm sure you can see. Some of the larger numbers, so there's 3 in the 50 to 100,000 and 2 cases that are over $1,000 owing. There are some factors that weigh into why these numbers are as high as they are on the outside. And the first is that some of these cases, the default cases have a lot of counts, and that just, it really adds up. In fact, I have here on the slide some as high as 21 counts. But I realized prior to appearing before you all today that there was a case that I got left out of the spreadsheet that I had with all the counts. And the highest counts that we have are actually 53. But most of those outliers do have in the late teens to early 20s on the number of counts. So that will increase the amount. The other factor that increases the amount that people owe is the interest. Like I've discussed on these older cases that have been renewed, once, maybe twice, we're doubling that fine every time. And so we do end up with some higher numbers on the edges.
Do we have any say in that, though? Is
No.
that so that's, I mean, I know you're pointing it out, but that's not anything we can control.
It's not much we can control.
Fine, they sort of subject themselves to that, right?
Correct. If they don't pay the fine, it goes to default, and that's what's there. And if they're not communicating with us, it goes to default, and that's kind of where it's at. And once it's there, we don't have control over the fact they're not paying the fine, and that we should be renewing our judgments. That's our job. So that's, yeah, it is what it is. But I wanted to explain why we have those 5 that seem really high. Mm-hmm.
You alluded to it earlier, but for the benefit of the public, could you kind of just, summarize why we don't have any control once it gets to a certain stage?
I think part of that is that the state of California does have an interest in collecting their debts. And I said part of that, but that is why. It's our job to collect on the debts and do what we can to assure that we've done everything in our power to get the funds that are owed. And that includes renewing our judgments.
All right, Commissioner Baker, I think I see you raising your hand.
Waving around. Yeah, thank you, Noah. Very much appreciate this. 2 things. One, you've used the terminology default in a couple of instances in your presentation. And I just want to clarify, when you're referring to default, like they haven't paid the judgment, as opposed to it was a default, they never engaged in the enforcement process. And so the judgment that was entered for them was, as we've seen come to us when there's a default matter. Can you clarify when you're using which term?
Executive Director West would like to clarify this one, so I'm going to
Sure.
send that to her.
So all of the 99 cases that we're talking about are enforcement defaults. So these are the ones that you see where the enforcement division has made 20 contacts and tried to negotiate. There are very few cases that go to default where someone's not cooperating. And those are generally where they don't want to make an admission of guilt. So they don't want to say, I did this and I signed this. They would rather just have a penalty against them. So there's really just those two scenarios, but we are talking about these same enforcement cases that were presented to you after multiple efforts by enforcement. And so now they're going through the process as a collection.
Okay, so that's the entire 99 cases that we're referring to.
Correct.
Okay, we're not referring to, or maybe this will be elsewhere in the presentation, where people entered a stip, or maybe we reached a conclusion through an actual hearing or otherwise, a judgment was found, and maybe they haven't fully paid what they agreed to pay.
Well,
Is that included anywhere?
Right.
Stipulation, they pay ahead of time.
For stipulations that we, enforcement always receives the money before it's presented to the commission. So we wouldn't ever be in this scenario, bird in the hand. So,
Okay.
yeah, so you're never presented with a stipulation where they haven't already received the funds. And then I would say that the second part of your point is really well taken, because some of these could be from hearings where the people have not paid the full amount of what was fined against them. I haven't gone through, I know Valerie and I haven't had time to go through each of them to figure out the specifics, but there could be a sprinkling of those.
And we are
In
still
the
working on it.
99?
In the 99.
Okay.
There's a lot of data to
Thank
compile.
Yeah. Super. That very, very helpful. I thank you so much on clarifying that. The second one is on the interest part. If we are in a payment plan with someone, and so they've responded finally and they're on the plan, and it could be a long one, how does interest accrue under that scenario?
This is under admin's purview, and I'm trying to figure out exactly how that process works. It is on the list of things to find out exactly how that process is.
It's a pretty, esoteric question to some degree, but I'm kind of curious when somebody's, on the track of getting good with their debts. I'm curious what interest is handled, and I can get that answer in the future. Thank you.
We've flagged that as a potential something we would like to know as well, and we're working on getting that information.
So in the presentation, we'll talk about the regulation and the things that we need definition on. And part of this discussion is about settling debt. And that will be in the regulation discussion at the end.
Mm-hmm.
Good. No, go for it.
I want to follow up on kind of generally what the question that Commissioner Baker asked, which I don't think was esoteric actually. I think to a certain extent we have to be, at least in my opinion, be sensitive to someone's financial or health hardship that they might be encountering. Are there any way or attempts to accommodate someone? Let's say they owe $20,000. Let's say they're on this list, but they're dealing with a severe health issue that came about. Is that a factor at all, or is that kind of out of our control?
Again, you're skipping ahead to my part.
Oh, I'm sorry.
So the second part of the second part of this presentation is about where we want to go from here. And part of that is a regulation that's on the books to be presented for pre-notice in May, I believe. And that will deal with giving authority possibly to me to be able to have some negotiation power, and what those parameters would be and what factors commissioners would be interested in seeing.
I have a related question, but I'll wait until your presentation.
And I'll stay up here in case something doesn't get quite answered.
Excellent. All right. Any more questions at this point, Ms. Nudin, though? If not, all right.
Okay.
Please continue.
When we're talking about these 99 cases and they all stem from default judgments, it sounds like a huge amount of cases. And this slideshow is really to get a snapshot of where they came from, what year they came from. And we're still working on getting the exact data on what year and what date exactly the judgment was acquired. we have been kind of replacing that date with renewals as they go. And so we're working on getting the exact judgment date. So these are FPPC case numbers. And that's why some of it stops off at 2018. Takes us a little time to get through to default judgments. And so when we're basing it off of FPPC case numbers, it's going to skew a little bit earlier, but it still shows you that we have cases dating back to the 90s, early 2000s, all the way through to present to 2018 to what's made it through the default judgment orders from the commission. If there are questions about this, I can answer it, but it's really just a visual to show just how far back some of these cases go.
So I have two questions. First one, I noticed that the numbers on the top row are all bolded.
Oh.
The other ones below, in the rows below, other than the year, are not. But is there any significance to that, or that's just?
I think that was just converting over.
I just wanted to make sure I wasn't missing something important. No, it's the second question though is, so if we look at this chart, these are all current enforcement defaults for which we have valid renewed judgments.
Maybe. So as we do this presentation, the acknowledgement that we're trying to make internally is the collections have been sitting for a while, and we haven't been actively pursuing them beyond what I'm going to discuss what our activities have been. So right now what has happened is we have taken steps, we've looked at what is owed to us, and we, the legal division along with administration has written a manual which has procedures, and we've changed duty statements to have people responsible for certain activities. So right now we're in a transition phase where we're looking at all the 99 cases and making sure that everything is renewed. And for ones that aren't renewed, I'll talk about what the options are that we can still pursue with those. But yeah, for right now, the reason we're doing this presentation now is to tell the commission where we are and then to show where we'd like to be.
And to kind of piggyback on that, and to answer really directly, the 99 are all the debts outstanding in the collections program.
All right. Commissioner Baker?
Is it possible that there are collections outstanding that we may not know about?
Is it possible? There's a question. I would say no. So I've been, Valerie and I have been working very closely with the administrative division, and we are pretty confident that 99 is everything. What we have found is that some haven't been registered with SCO, the State Controller's Office. So our debt numbers are different from theirs, but we have identified which of those, and we're going to have those all incorporated into the system. The State Controller's Office works as the protector of debt for the state. So anytime that we say something is a bad debt, we don't want to pursue it anymore, they're the ones that we would apply to. And so for them to have accurate records, that's one of our big priorities. But I have pretty good confidence that administration, along with the legal division, has now been involved. Caitlin, who's out on leave right now, and Valerie's taking it over, have found all the cases.
And if I may follow up, Ms. Chair, do we have prior to now in this report and this process that you've mentioned, kind of making sure everything's gathered, have we had a process similar to statute of limitations tracking, like either in the software, or have we had a procedure prior to this for tracking judgments and collections?
So in 2015, the program of collections was transferred to administration. So prior to that, enforcement was tasked with the entire collections process. There used to be an employee assigned to that, and when they left, we discovered some records that we needed to follow up on. And so actually General Counsel Bainbridge at that time took on the task of organizing all of the records, figuring out what was still good debt. And in 2015, we changed the process to move to administration. And that's when the procedures started to get put into place. We started to make sure that we were tracking everything. So we are finding some things were not held on to. They weren't completely tracked appropriately, which is why we're doing this and we're shining a light on it. We're making sure that everything is moving forward, has dates and times and spreadsheets, and there are people assigned to these tasks and responsible for them.
Thank you. No, I appreciate that. And it's excellent when a governmental entity not only identifies where there may human error or whatever has caused maybe some things to slip through, and you tackle it, you shine a light on it, you work on it. So I'm extremely grateful for that. I just wanted to get a handle on just how it was. It's similar to the statute of limitations tracking. Is it person specific, or is it is in a system? So if that person wins the lottery and moves to Hawaii or something, that, it'll pop up somehow. It'll be triggered that this is a responsibility that needs to be covered.
Yes, so there's several people in administration that have access to it, as well as there's a corresponding spreadsheet in the legal division.
Okay. Well, I thank you for that. Looking forward to the rest of the presentation.
Any other questions at this point? All right, please continue.
At this point, I'm going to pass my remote on to Executive Director West, but I will stay up in case any process questions arise.
Thank you.
I don't know. I'll let you. So generally when I touch technology, it stops working. So I'm happy to see that still worked. Okay, so as we were talking about, Valerie, I'm sorry, I should say Ms. Nudie, has said 99 cases. So that's about $1.7 million due to us. And a lot of that is interest. And this is what our success rate up to now is. So in the next slide, I'll tell you more of what our efforts have been, but let's just say that collections hasn't been prioritized by the commission in the last decade. So the collections efforts have been minimal, and that's one of the things we're bringing this to the commission's attention so that we can ramp up efforts a little bit and then also have discretion to settle some of these debts. So as you can see, we have collected $47,000 on those debts between the fiscal years 2019 to 2023, which is about, over the time period of the life of these enforcement actions, about 15% of what is the total fines that have been instituted by the commission over the years, and about 7% if you include interest. Okay. Hey.
I'm sorry, Director West, if I may ask. Can you repeat those numbers again, just on the percentages?
They're estimated. They're estimated numbers. So based on the records that we have right now, our estimation is we've had about a 15% success rate on the original amount fined that was passed by the commission, and about a 7% if you include interest.
Okay, thank you.
So that brings us to the collection options that are available to the commission. So Offset is a program that we participate in every year for all of our collections as a matter of course. The administration division applies to Franchise Tax Board with any debt that they have a Social Security number for. And then any tax refunds, state lottery winnings, anything like that that goes to Franchise Tax Board is then intercepted and provided to the general fund as a payment of our debt. We also have the opportunity to do liens on debtors' real or personal business property, and wage garnishment, which isn't as aggressive as it sounds because you're limited to what is above the federal minimum wage, the hourly amount, and it's a percentage of that. We have the opportunity to do payment plans, and we can levy on bank accounts. This is considered a very extreme measure, but we also can levy campaign bank accounts. That also sounds really exciting until you realize that these are defaulters who have probably cleaned out their bank account many, many years ago, since the case has been in effect for many years. And then other more extreme collection mechanisms that are available is you can have their house foreclosed on and sold at auction, and have the sheriff take their car, and very extreme measures of that last paragraph there.
Can I ask a till tap?
Yeah, you go in their business and
Till they
take
their
money. Yeah, the sheriff does that. I mean, it sounds kind of cool, but I mean, it's very invasive, very extreme measure.
Yeah.
So these collection options, which you described in detail, are we exercising any of these with the pending cases?
Great question. So our current policy and what we are proposing to get more aggressive from is that we do the offset as a matter of course. And that is the collection as well as letters and other contact. That is what has been done for about the last decade. So what we're proposing is to continue with offset, and I'm going to go to the next slide so you can see it. That we continue with the offset program, and then we add liens, and the real property liens would be added anytime there's a renewal of a judgment, or when the judgment is first brought over to admin, then the lien would be put on as a matter of course. It would just be regular practice. Then we're also, it'd be good if I had my glasses. Oh, we would do that as they come in, but we would also prioritize the more serious cases identified by the commission as more egregious violations of the act. So as Ms. Nuding and I can go through with the admin division and look at some of these cases, as she's broken them down on that one chart, we can see the different violations. I just realized she took that chart out. So we can see the different violations, and if there's, say, conflicts of interest or something that the commission considers more egregious, we can make sure the liens get put on as a priority instead of waiting for a renewal. So that's the third recommendation. And then the last recommendation is clarifying the authority to negotiate settlement, which is the next slide that we're going to talk about, the legal division project, where we would have more authority that's actually explicit authority as opposed to just implied authority, that I would be able to negotiate some of these settlements, especially if there's a great amount of interest that has accrued. And then the fifth recommendation that's not on there is that we would come back and report to the commission yearly on the progress of the different kind of collection procedures that we have put in place. What is the success? Have things been going well? Are there other things we should get a recommendation for the commission to pursue? And kind of give a status update so that everybody's on the same page, and that this collections process doesn't get forgotten or deprioritized, since it is a state mandate.
I think taking that last point, I think that's important. I mean, I suspect it's like out of sight, out of mind. Prior commissions, this wasn't on their radar, and so it happens. So I think that's a great recommendation. I want to just clarify something though, because you have the recommendations, and I know you have another slide after that on regulation, and you're kind of talking about both things right now. And so with respect to your authority and staff's authority to continue the offset program, to decide liens, wage amount, your list on options, wage garnishment, payment plans, those are all things you can do today without any action by the commission. You have existing authority to do it. It's the settlement of a debt and the parameters for that would be the focus of the regulation. Is that right?
That is correct. And I think the most important part of that is those are the options, but we also want to get the temperature of the commission as to how aggressive they want to be moving forward. Because as Commissioner Wilson rightly pointed out, the last 10 years, commission has just said, tax intercept's fine. And then the chair points out it hasn't really been a priority or something we've looked at. So having the commission say, no, staff, we do want you to we like your recommendations. We want you to do liens as a matter of course. We want you to have a higher success rate. But on the flip side of that, this regulation is the authority to look at these debts and do a cost benefit ratio and see how much we're spending on collections to do these extra efforts, how much the person actually has. So when you get to the next slide, you'll see we want criteria for consideration for these settlements. The amount offered is more than the FPPC can expect to be paid or collect within a reasonable amount of time. The debtor does not have reasonable process of acquiring increased income or assets that would enable us to satisfy the liability. But also there's other criteria we can look at. We can look at, has the amount of interest made the debt unpayable for the person? Have they had a change in circumstances to where now payment of a debt of that type or that size is not feasible? So when we're looking at the regulation moving forward, the chair's point is correct that we are looking for the authority and the guidance from the commission about what the commission considers proper criteria to consider when settling these debts.
Okay, that's helpful. Going back though to your existing authority that you don't need a reg for with respect to liens, I want to make sure I'm understanding your chart on recommendations. Number 2 says adding liens with new judgments and renewals of judgments. But then 3 says prioritizing addition of liens. Why wouldn't we just put a lien on as a matter of course when we have a judgment? I thought, my understanding was that's a relatively simple process.
Sure. It's just resources because Ms. Nuding has other job in the legal division to write advice letters and regulations. So it's just resources to where she and the administration division would be prioritizing the new ones and then also the ones that are up for renewal. I think there's maybe 6 up for renewal this year, 6 or 7. And so it would be another policy could be just start at the oldest and make sure we get liens on everything. But we are thinking that since some are more egregious violations and that have never paid for any of those egregious violations, that we would prioritize those and put them to the front of the line and say, we want to get the liens on ASAP for these types of violations. So we could go either way.
Well, that's what I'm trying to understand. I'm sorry if I'm just not understanding you correctly, but is it you do it as a matter of course, but when you're looking at your stack of things to do, you're going to prioritize the most egregious, which totally makes sense from a prioritization standpoint, or are you saying we're only putting liens on the serious cases? That's what I'm trying to understand.
Sorry, yes. It would be prioritizing those serious ones. Yeah. We hope to have liens on all of the 99 cases at some point. And that's the end goal. I'm sorry if that was unclear.
No, I think I'm just tired maybe. Thank you. Okay. Commissioner Baker?
Yes, so on this point, several actually, I think you may still get to them, but on the chair's point in particular, the amount of time put in a lien is different than renewing the judgment, right? If I remember correctly, Ms. Nuding was saying renewing the judgment is not a terribly complex undertaking. I think it's like a form you file with the court. I can't remember from days gone by. But the amount of time to get a lien, can you give us a sense? Because, we're talking about 99 cases out of all the thousands that come before us, a lot of money. What's the amount of time that a lien would take?
So
Similar
I
to
can,
the question. Yeah.
I can address that question. When we're getting the lien, if a case is going to be renewed, we might as well wait for the renewal of if it's getting renewed next month, you wait for that because then you get the accurate interest to include when you file the lien. So once it's been renewed, you have to get a certified copy of that renewal. So you have to wait for the renewal to be ordered. Then you have to go and physically get the certified copy from the Superior Court. Then we fill out we run another skip trace so we know where the property is located. So we reach out to an investigator. Then there's another cover sheet that you fill out that basically says we work for the government and we don't owe you a filing fee. And you conclude that with the certified copy and you mail it to the county where the property is. They take some time to process it, especially because it's by snail mail, and they will mail you back a confirmation that they have recorded it. So it's a lot of waiting, I guess. Again, the actual steps that we have to do physically in the office and filling out paperwork is not extensive, but there is a lot of waiting for steps to come through, waiting for other counties, waiting for the. Yeah.
Can I ask you I'm curious. So when I was in private practice, we had paralegals, or even like sometimes just legal assistants who would fill out the paperwork for us, and then you just review it and sign it off. I mean, I know we have those here in the agency. So as part of this process, I mean, wouldn't you make use of that as part of what you're doing?
And when I say we, I was talking about the team effort, and I apologize, I didn't delineate that clearly. Admin will get the certified copy. Admin will prepare the paperwork. I will sign off on it. Admin will mail. We will wait for the return. It's more of a process for admin than it is for the attorney reviewing the case.
And you said snail mail? Would it just be sent to regular mail, or would it be sent via, expedited mail using UPS or something like that? I mean,
I believe it's regular mail. I said snail mail in the sense that we can't send it electronically, but I believe it's just through the regular mailing process.
Thank you.
Sorry, Commissioner.
And just to share, well, no, not at all. These are good questions. So in follow-up, I appreciate that it perhaps more of the time is waiting for other inputs and people to close it, but not our own staff time. I don't want to be unfair here. Is it correct to characterize it's not a lot of time? I mean, they're not filing a brief. They're not doing legal research. It's fairly administrative. And so it doesn't take a lot of time to do the work of putting a lien request out there. I don't want to, be unfair to the team that does it. I just am trying to get accurate on that before we suggest we do more liens.
Larissa Hahn, the chief of admin, is going to come up and talk more about the impact on admin.
After, later in the presentation, or right now?
Right now.
You just can't see.
Oh, thank you.
I will.
Thank
For the record, Ms. Hahn has approached and is now sitting at the table.
Good afternoon, Chairs and Commissioner. Larissa Hahn, Chief Administrations. So Commissioner Baker, to answer your questions is, one, the admin division have never done a lien, so there will be a learning process for us to actually learn how to do the lien paperwork to begin with. And then two is we don't have additional resources, as we currently only help and assist enforcement division or the legal division to do the judgment. So lien itself, it's not a whole lot of paperwork, but there's a lot of form and different counties that we never dealt with that we would have to begin dealing with the court over there in those local jurisdiction. So those are the time and resources that would take for admin to fill out the form, because each of the 99 cases might be spread out in California. And then so we don't know where the county or work with those county jurisdiction before. So we would have to first establish who to go to and where it goes to, and learning the whole process itself and how to fill out the form correctly, because every county has a different standard on their liens. I think there's different forms that you have to fill out. And even the information within the form itself. So it would be new to us. So that's the resources that we would have to take to learn and then to progress on those forms and the process itself.
Thank you. I certainly understand a learning curve in anything. I wasn't aware. So we've never done a lien on any judgments before.
Within the past 10 years.
Okay.
So in this current administration staff's history.
And would, thank you, Chair, for letting me continue on this, just one point. So I'm wondering, are there other, sometimes the Attorney General's office is our legal advisor in litigation or representative. If they have people who might really be quite experienced in this that either can come over and train our folks or do it for us, are there other options that might make some things even more efficient? I'm just curious.
We determined that keeping it in-house is probably going to end up being the most efficient. Over the years, the commission has tried different things. We had the Attorney General's office handle collections for us for several years, and we received $0. So it wasn't a priority for them, so it never got emphasized.
Understood.
there.
We can't control. Yeah, sure. Yeah.
Right.
Okay.
But yes,
Very
it is a
diplomatic,
free service for us. So
Very
yes,
diplomatically reported.
thank you. So we've also looked into doing debt collecting agencies and things, and the cost just isn't worth it for the number of cases that we have and the amount that we would collect. So, and we also want more control over the tone and tenor in the way that we interact with the debtors that owe to the FPPC.
Thank you.
All right. Commissioner Baker, Commissioner Wilson has a question. Are you done?
Oh, no, yeah, on that particular point, I'm done. I'll have other questions, but I don't think this is the right spot to get them. So thank you.
Okay, cool.
I have some other questions as your presentation progresses, but this is more of a technical question. If there's a judgment against someone that's gone to Superior Court, does it show up on their credit report? So if, for example, they go to refinance their mortgage, will it show up on a credit report? Because
I know
you
the
understand why I'm
liens
asking that
do.
question.
Yeah, I know the liens do. I'm not sure the judgments do.
That's essentially what I'd say. The lien encumbers the property. So if you're going to refinance or sell, it will come up. I don't have information that's on a credit report. Yeah.
The reason I'm asking that question is, if I'm getting ready to buy a new house and I had a judgment against me and it's not on my credit report, I'm going to prioritize my debts and I'm not going to make this a priority.
I've got an answer from Google so take that for what it's worth.
Just
I knew that joke was coming. It says judgments do not appear in credit reports, but they don't affect your credit score, but judgments may impact your ability to qualify for credit since lenders can search for judgments via public records. Experian is the source.
And the good thing about
Thank you.
the property liens is that they're for the property that's owned at the time that they're filed, as well as anything they cover any future property owned.
All right. Any other questions for Executive Director West or Ms. Nuding at this point? All right, Executive Director West.
Final slide. So you've heard our recommendations, and one of those recommendations is to have the upcoming regulation clarify the delegation of authority. So we say clarify because there is some indication in the history of the agency that the authority of the executive director has included this ability, and there was a 25-year-old delegation, I believe General Counsel Bainbridge found. And so we do know that there is some history that this power may exist, but we and the administration division would prefer it to be more explicit. So that's why regulation is needed to clarify. We're recommending that the authority be placed with the executive director, but that's just for practical reasons to work with and oversee both administration and the legal division. And then, as we stated earlier, that we would want to provide some criteria through the regulation as to considerations for when settlement should be an option.
Commissioner Wilson.
Thank you for the summary. I'm just speaking for myself here. I think it's very important that whatever policy we adopt, we take into consideration an individual's financial hardship, their health, just so that there's a certain level of sensitivity in dealing with each case, based on the merits. But if there's someone who's just, I prefer to use that money for vacations and I'm not going to pay you any money, that we should use every option available, to us to pursue that debt. But I do think it's important to have some kind of exception in place when it comes to individuals whose situation has changed dramatically. In this one case, it's over 30 years old, dating back to 1989. I mean, if I'm 85 years old, 90 years old, and you're coming to collect a debt, I'm not gonna return your call. So I think there needs to be a certain level of sensitivity it looks like you're moving in that direction. So thank you.
Yeah, I agree with that sentiment, by the way. Commissioner Baker?
I also agree. I thank Commissioner Wilson for raising it. I would want the executive director to have the discretion to take factors into consideration. Certainly the health, I won't make somebody homeless because they didn't pay a fine like this necessarily. I imagine that at least my one perspective is making sure that, yes, there may be hardship, but that's what happens when you have a judgment that is against you. I wouldn't want it to be an easy out for someone. It would be in the cases where really someone's health and ability to maintain decent living circumstances and not be put out on the street because of an FPPC fine. So that's my feedback to supplement with Commissioner Wilson's for what it's worth. And then secondly, that when that discretion is used, similar to how we've begun to have more reporting to the commission from the enforcement division, that it would be reported to us, and that there's almost a standing order that there will be a annual look at collections, and that this is one of the features. And if in fact, you use that discretion before the next annual report, it can go in the executive director's report that comes to us on a monthly basis. I think that is good, so that when we all move on to different things and there's new personnel leading way off into the future, there's good practices in place. I do have a question. If you were to use people can go through a bankruptcy process if they have too many debts, right? And if there is I imagine this, if we have a judgment against someone and they can't pay, they might have a lot of judgments against them, but they go to the bankruptcy process. That's one way in which, out of our control, it's potentially cleared. Do you happen to know what the law is on that? I'm not a bankruptcy person.
Yeah, ours is like student loans. It's not extinguishable in bankruptcy.
Okay, very helpful to know. Okay. Yeah. I also want to thank you again for drawing attention to how things haven't been ideal and that we are getting our own house in order on this, which I think is good. In addition to these regulations, and perhaps Chief Hahn will mention this, do you believe there is any additional resources our folks need, whether it's technology or personnel, to do this work? I think it would be a steep climb to need additional personnel, but can you comment at this time on what additional resources, if any, you might need?
I think I'll go ahead and answer that. So what we're looking at is doing this incrementally. I mean, that's what the question, the back and forth with the chair was about. Like, are we trying to tackle all 99 of these right now? No, we're incorporating this into current workload. So there's not going to be a legal division attorney spending 40 hours doing this every week. There's not going to be someone in admin spending their entire time. We're incorporating these good practices and procedures into our current structure. So I think that's a great idea to look at technology, because right now we are using Excel spreadsheets to track and do these things. And as Chief Hahn said, different counties have different requirements. So I do think as we get more experience, it's similar to what legal was saying about once they get the questions and they'll know what they need. And I think this is really similar. Once we're doing it more and we're interacting with these other jurisdictions, then we're going to be able to see what our need is that's going to help us. So that's definitely something we're going to keep in mind.
And Mr. Chair, I don't want to hog the time here. I do have two more questions, but they're not on this point. So I leave to you if others want to follow up first.
Anybody want to jump in? All right, Commissioner Baker, go ahead.
Thanks. Can you or any member of the team say a little bit more about the profile that these 99 tend to fit? Are like, what portion of them might be folks who are thumbing their nose at us, like, I don't care, I don't want to pay this. This is some commission out there we've never heard of. I just ran a campaign once, and who cares, to the folks who are in some sort of particular financial stress?
I don't think we currently have that information, but I think that by the experience of this commission, they can see the collections cases that have been presented to you are the people that are not participating. The people that enforcement gives you almost an entire page of bullet points of them trying to reach out to. So I think you can assume that these are already people that have completely disengaged.
And I think my last one, and thank you, colleagues, for tolerating, is that skip trace that was mentioned very early in the process. Is that something that is done during the default process? I know when we do get a long list of all the contacts that have been made and attempts and where they went to addresses. Is a skip trace part of that, given the consequences of entering default?
It is, because remember, part of the process is the accusation has to be personally served. So as enforcement goes through their process, they've already at probable cause had to get a good address. At accusation, they've had to personally serve or even have good substitute service in very slim circumstances. And then the default documents have their own service requirements. So the enforcement investigators are constantly trying to get the most current information through. That's the mechanism that we have for them to use. So as we try to communicate with people, we're constantly looking for a better email address, a better physical address, a good work address. So it's a tool that's used very often through the process. Mm-hmm. Sorry, I don't know where to look to see you, so I'm kind of just looking off into space.
That's okay. Look at that empty chair that is that is there. You had one this last bullet point on maybe one area of discretion in the regulations. The debtor doesn't have reasonable prospects of acquiring increased income. Were you anticipating having the authority to then say, this is the final, we're ready to be done with this? And if the person does get income down the road, 5 years later, they get a great job or something, that we can come back? Or are you looking to, we want to close this, turn the page and move on? Is that the type of flexibility you'd like to have?
We are closing, turning the page and move on. We're looking for, it's not just the debtor had a bad year. We're looking for now they're on permanent disability. We're looking for the things where they have changed circumstances. And yes, this would be, this is the end of the bargain. This is it. This is your best offer. And we're not talking about zero. So I'm not looking for authority in this regulation to go down to zero, because that is an SEO process. So we can negotiate down, but we can't eliminate the debt through this process. So just to clarify what the regulation would do.
Thank you very much. Very informative.
What is you said you can't go to zero, but could you do $1? I'm just giving, what is the
my legal advisor has said that I might be able to do $1.
Well, and part of the reason I asked is I actually had written down in my notes discharging debts. Mm-hmm. And so as we're doing this, because I take it from this presentation, which is very candid, that we truly don't know some of these old cases. I mean, the 1989 case, maybe there is no judgment renewal. And so our options are severely limited. Maybe that person has passed or is in the hospital, whatever the case may be. There may be circumstances where we're never going to get anything. And so how do we just get it off the books at that point and come to terms with it? So you're not asking for discharge then, but what do we do?
So that's a different process. And in fact, we actually have an expert on this process, because when General Counsel Bainbridge was in enforcement, he cleaned up all of the collections records back in 2014, 2015, and went through, found out who was deceased. And so that application process is through the state controller's office. And then they, based on your application, determine if it is a bad debt that you no longer have to collect on. And then it's expunged from the books. Did you have anything you wanted to add?
Okay. Well, so let me ask you this. You're asking us to clarify your settlement authority. You, though, as part of this process, identify some cases that fall in the category of we think we want to. These are likely to be dischargeable, I guess is a term. What's our process for identifying that, and who's going to undertake the discharge? Have we thought about that?
So that's more of a next step. So as Ms. Nooning and I and admin go through all of the cases and identify whose judgments have lapsed, who is, because just to clarify, I said I would say it later, and I don't know if I actually did. If the judgment has lapsed, our only collection means is through the intercept programs to get tax refunds and lottery winnings. The only thing that we could look into at that point is other agencies. Department of Finance says, hey, there's other agencies that also collect taxes and give refunds like BOE and EDD. So there are those avenues we could go down if we end up finding that there's several or a dozen that don't have judgments. So those would all be things that we have to gather all of the data first and then determine what the best path forward is. And some of those will be recommending discharge.
What about the flip side? Suppose we have somebody who has defaulted and they, we see on social media they're in Hawaii at a beach house and they're living it up. So clearly they have money. Do you need additional, how do you exercise what I would characterize as the more extreme options that you identified, wage garnishment, et cetera, when you see that type of behavior?
I think that nothing the commission has said today is giving us the indication that these options are not available as the staff and executive director day to day. So if it's egregious, then I see that we have all of these at our disposal. So if they have a campaign account, or if they obviously work for, I'm going to say Enron because that doesn't exist. And so not picking on anyone. And so if we get that kind of information, then we can be more aggressive. And of course, in coordination with the chair.
Okay. So that's something that you as the executive director would already be keeping your eye on, and you have the existing authority to do something.
Yes, because the direction to staff, both the legal division and admin, is we're changing stance here. We're becoming more aggressive. We're trying to not have $1.7 million of outstanding debt. So what we're trying to do is have practices in place where we're identifying the more egregious ones. We're identifying the ones that we have a likelihood of success, and we're pursuing.
That's great. All right. Any Commissioner Baker?
Thank you. Posing some great questions. This comes up in mind. I'm thinking of the family law cases that I'm aware of happen all the time, where some member of the divorcing couple has done a great job of sequestering their resources away so that, they're not potentially subject to a divorce proceeding. Is part of this process of trying to get good collection on a judgment include sleuthing around to see if the person has tucked away or transferred their house or transferred things that people do to avoid judgment, especially in these bigger ones? Do you have that authority now, and is it part of the process?
As of right now, the new direction is we're spending more resources on this than we have in the past, but we're not spending entire resources on this. So sleuthing around is probably not happening in the near future. But once the collections cases are under control and everybody is familiar with their roles and it's become more automatic and all our liens are filed, then I could see that being on the table in a later iteration. Because, we do have wonderful investigators on staff who I think could poke around very successfully. But then it becomes, how much of the legal resources do you want to spend to try to prove that somebody owns something in order to put a lien on it? So it becomes that cost benefit ratio, and we have to sort of figure out, do we even have the resources to really go down that path? It would have to be pretty egregious.
Yeah. And for my part, I would just, again, both leave to you and the team of people you work with on a daily basis. If there are those cases where before, that page is turned and brought to a close, you may consider if that extra check needs to happen. So I just leave it there, and certainly can understand, again, we're getting our own house in order before maybe going to new levels. Other one was, and I welcome colleagues' thoughts on this, but yours, are you anticipating, based on the feedback you've received today, that you would come to the commission after exercising discretion, or similar to how the enforcement team brings stipulations to us, before a judgment has been, your discretion has been used to curtail or forgive to the extent the law allows. What kind of feedback do you think you've gotten? And I'm curious which we would prefer.
So for the regulation and how it's going to be written, I have an opinion, and the opinion is that it should be the easiest to use as possible, which would be not waiting for a commission meeting in order to get authority to then settle a debt for somebody that was squirrely to begin with. So, and that's a technical term, by the way, squirrely. So, it's really, these things are alive and happening. And so I think that it would be more of a reporting back would be my preference. And then if the commission said, hey, we think you're, giving too good a deals, or we think that this guy was not honest with you or whatever, then we can look at narrowing it or deciding what criteria should be emphasized or changed. And I think that's a more effective way to do it because it's more of a day-to-day business kind of factor. So it would just be in the matter of business with admin and legal and getting things through the process and then reporting back. So that's kind of how I see it.
Yeah, I mean, that's kind of how for my piece, that's how I envision it too. It's very much like Streamline. The commission's role is to set the parameters, and then it is for the executive director or the chief enforcement in the case of Streamline to exercise their discretion. We receive reports back. If we don't like the way you're exercising your discretion, we tighten the parameters. I mean, but that's just my 2 cents. Commissioner Wilson.
I think Commissioner Baker raises a good, excellent question. Executive Director West, there's a list of 99 individuals, right? 99 cases of default. Obviously, we shouldn't be discussing this at, that list at a FPPC meeting, but what is the scope of confidentiality with regard to that list?
So all the collections information is public. So it's who owes us money and how much is reported to SEO. Those are public reports. How much is owed to us is a public number. We inconsistently get press reports for the requests for those numbers, and we provide it. And so if people want to know if we have a lien against somebody or a judgment against somebody, that's all public.
All right, thank you.
Any further questions or comments for Executive Director West? Commissioner Baker?
No, I would just say on that point about when you're coming to us before or after discretion, I'll probably put a little bit more thought into it. It sounds like we're going to see regulations come to us for pre-notice in May. Is that what you're anticipating? And because I would agree, maybe in cleaning the house, I'd want you to, I have to decide if it's closer to when a stipulation's brought to us because it's not Streamline, or if it is like Streamline. So I'm just giving that feedback for now. I'll probably ruminate on that between now and May, but it's still out there. Thank you.
Any further questions? Commissioner Wood, anything further for Executive Director West?
No, I've really enjoyed the conversation, but I don't have anything to add to it because you guys have been so thorough. So thank you.
All right, thanks. All right.
Can I make a quick correction?
Yes, of course.
This will be very quick.
Yes.
The collections pre-notice will be in June, not in May. So you have to wait till June.
All right.
But it'll give everyone time to think about what they think the proper parameters should be.
There we go, Mr. Cambridge. Always looking on the bright side. All right. So at this point, I will call for public comment. We are on item 7. This is an informational presentation on the FPPC collections procedures. Hearing and seeing none. Thank you, Ms. Newton. Thank you, Executive Director West. Great presentation. We look forward to the pre-notice discussion in June on the regs.
Thank you, Chair and Commissioners.
All right, we'll move on to our next item. It's item 8. It's our legislative update with our senior FPPC Legislative Counsel, Ms. Nakano. Good afternoon, Ms. Nakano.
Good afternoon, Mr. Chair, Commissioners. All right, lots of updates today. First, I'll go over a general summary of where we are in the legislative process. This week, Tuesday and Thursday, the Senate and Assembly Elections Committees had their last hearings for bills introduced in their House. Most of the bills affecting the PRA have cleared this first hurdle, and I will go through each bill individually. The successful bills will now be headed to one of three places: to the Appropriations Committee in the House of Origin, to another policy committee if the bill was double referred to a second policy committee, or to the floor if the bill is non-fiscal. Before I get into the individual bill updates, I wanted to give notice that two authors' offices reached out to request the Commission's support on their bills. SB 328 by Senator Dodd relating to extending the contribution limits to all local government agencies, and SB 858 by Senator Nilo relating to making the legislative analyst, instead of the Attorney General, responsible for creating ballot measure titles and summaries on the ballot. I'll give more information on those a bit later. Okay, I'll now go over each bill in the order in the legislation update. The first is AB 868 by Assemblymember Wilson. The bill would create a public record of state-level online campaign ads. That bill passed in the Assembly Elections Committee 6-2 and will be heard next in the Assembly Appropriations Committee. AB 1170 by Assemblymember Valencia was a spot bill. Then it was amended to include the Commission's proposal requiring electronic filing of statements of economic interests for certain individuals. However, the author's office received concerns from some legislative staff about the requirement to file exclusively electronically. Some individuals wanted to retain the ability to file on paper. The author's office didn't believe that these concerns could be resolved before the bill was heard in the first policy committee, so the author's office opted to make this a 2-year bill that may be taken back up next year. So to be clear, this bill is on pause until next year. All right, SB 29 by Senator Glazer relating to the Commission's Political Reform Education Program passed in the Senate Elections Committee 7-0 and is now on the suspense file in the Appropriations Committee. SB 678 by Senator Umberg. This relates to adding a disclaimer requirement for online posts by third parties who were paid by committees in connection with that post. It passed in the Senate Elections Committee 7-0. Earlier, Senior Commission Counsel Boyd highlighted that there are some related ambiguities in existing law as a result of last year's Bill SB 1360, and we are attempting to resolve those ambiguities by adding some clarifications to SB 678 this year. SB 888, a committee bill of the Senate Elections Committee, is now the vehicle for the Commission's several minor and cleanup changes, as well as the changes relating to redaction of private information on campaign statements. The bill was amended again this past Monday, the 17th. Those amendments do two things. They delete from the bill the change relating to personal loans, so that will remain as it is in existing statute. And second, the bill adds a new proposal to this now omnibus PRA bill. This new proposal makes amendments relating to FPPC commissioners and when and how they are restricted from seeking public office. Existing law prohibits a member of the commission from seeking election to any other public office during the member's term of appointment. So under existing law, a commissioner cannot seek public office during their 4-year term, even if the commissioner ends their term early. The amendments made by SB 888 would strike that prohibition and replace it with two new provisions. The first would add that if a member of the commission declares a candidacy for elective office, the member shall resign from the commission. So there would no longer be any prohibition on seeking office during a commissioner's 4-year term or while they are serving, so long as they resigned from the commission before or after declaring candidacy. The second addition would prohibit a chair of the commission from filing to be a candidate for elective office for 1 year after service in the position expires. So this amounts to a 1-year cooling off period for a former chair of the commission, during which that former chair could not file to be a candidate. In total, these amendments appear to make rules for commissioners seeking office less restrictive, except the rule for the chair or former chair seeking office would be more restrictive than current law.
Ms. Nakano.
Yes.
I just have a question. This is kind of coming up at the last second here. Did the author give any, or this is a committee bill, did the committee discuss any rationale? I mean, what's the problem they're trying to solve?
There was no discussion in committee. It was heard. It passed on consent unanimously. According to the staff person on the bill, the amendments relating to commissioners were intended as a clarification, as they said the phrases term of appointment and seek election in existing law were thought to be ambiguous. However, FPPC staff see this as a substantive policy change that goes beyond clarification. And there was no information or background available on the change relating to the chair of the commission.
All right, appreciate it. Thank you.
Okay, that bill, as I said, passed in the Senate Elections Committee. It's headed next to the Senate Judiciary Committee. And that's the end of the commission-initiated bills, rather. Any other questions or comments on those before I move on?
Any questions or comments from other commissioners?
My only question is, given that that's a commission-sponsored bill, I don't know if we make that decision now, but do we continue to support that bill, or do we take a neutral position because it impacts us directly? Not that I'm planning to run for office or anything, but it does impact us theoretically down the line. So perhaps we could look at if we continue our support or if we take a neutral position moving forward. But we don't have to decide that today because the bill is still in the Senate, correct?
Still in the Senate, yes.
Right.
And for this one, it was commission initiated. I don't believe the commission has taken a position yet, so we don't have an official position in writing.
But if we initiated it,
right.
It's the same thing.
Unless I'm misreading the minutes, we did vote last month to support Senate Bill 888, and I think Commissioner Wilson. And this isn't. Look, we've done this in years past. Things that we supported are amended over time, and we revisit them when they're substantive amendments, as is the case here. And so I'd suggest that we revisit the issue in future months after we receive some input from the committee as to the rationale, so we have some time to kind of think it through.
And I think we ought to, I don't have a position one way or the other. I know that a lot of what we do is mirrored based on, the PUC, Public Utilities Commission, not to use the acronym. So I don't know what laws or policies apply with the PUC, but that might be something to look at as well, so that, we can make a informed, decision moving forward.
Thank you. Okay, moving on. AB 37 by Assemblymember Bonta. This is a bill that would make changes to expand permitted use of campaign funds for security expenses, passed in the Assembly Elections Committee 7-0. There were some questions about this bill that came up during the last commission meeting, including what is the problem the bill is aiming to solve. According to the author's office, to summarize, there are hurdles for expending campaign funds on security expenses that don't exist for other types of expenses. For example, candidates are not required to show proof of need for other types of expenditures. Regarding a potential monetary threshold, the author's office responded that different officials would have different security needs. So I think the implication here is that it would be difficult to choose an appropriate limit because of these potentially different needs. I also asked about whether they have seen a demonstrated need to expand the law to allow security for staff of candidates and elected officials. And they responded that they don't have statistics, but staff are included in the bill as a precaution. And if threats are significant enough to warrant extra security for staff, they'd like to have that flexibility. They also pointed out that on social media, it's not uncommon for staff to be tagged in posts by the campaign or elected officer, which creates some opportunity for staff to be targeted. There are also questions about reimbursement and whether security systems could be treated like other tangible campaign equipment. Based on my understanding so far, campaign equipment like cell phones and laptops can only be retained by staff after the committee terminates or the person leaves office if the staff person purchases the equipment from the committee based on fair market value. Last on this bill, I wanted to make a clarification. The bill would repeal the current requirement that the committee submit a separate report directly to the FPPC specifically about expenditures for security, but these expenditures would still be reported on regular campaign statements.
Can I ask a quick question on the reimbursement issue, just so I understand what you just told us? So if a staff member wants to keep the campaign purchased cell phone at the conclusion of the campaign or their employment, they have to pay the fair market value in order to keep it. But under this bill, if this was law, a staff member could have been provided with a home security system for their entire house, and there would be no obligation to reimburse the committee once they leave office.
That's right. The bill is silent as to reimbursement. It removed the prior provision relating to reimbursement that required security systems, required those individuals to reimburse the committee upon the sale of the property that the security system was on. So as the bill is silent now, they would not be required to make any reimbursement.
And there's no limit on the number of staff members who you could provide a security system to.
Correct.
Is there any time limit? I mean, could they provide the security system like the last week that they worked there?
No, there's no limits on time.
Okay. I just wanted to make sure I understood. Thank you.
Okay.
Any, I don't know, Commissioner Baker, do you have a question?
Thank you. I shared in those questions. First, I'd like to just go back to your clarification, because I know the last paragraph on page 8 of the Ledge report mentions the repeal of the reporting requirement. And I think what you said was just a little bit different than how I read that paragraph. To be clear, if under existing version of the bill, if campaign funds are used for security purposes, that expenditure will still show up on their filing reports, so the public can know about it. Is that correct? It's just the report to us about the threat is discontinued.
Yes, that's correct. They'd still report the expenditure on their regular campaign statements, but the separate report that comes to the FPPC would no longer happen or be required.
Okay. Thank you. And then going back to the top of the page on about expansion to family and staff. It says here in the summary, immediate family. I want to caricature this, but so if this were to pass in its current form, it seems to me that potentially a lot of family members could have security systems in their homes added with no need to justify or even report to us after the fact, because it's repealing the requirement that it come to us as well as the police. I want to be sure I'm accurate on that. There really is no limit. If you've got 7 brothers and sisters, if you've got 5 kids, if you've got, parents, every immediate family, however that's defined, without limitation, can have a security system installed with no prior or post justification to anybody about it. That's how I'm reading the immediate family part. No limitation on cost and no limitation on how many members, and no reporting to anybody to substantiate it.
I think that's correct. There are no limits as to, or the bill itself does not define immediate family. I don't know if there's an applicable definition in the PRA currently, but if not, that could be defined in regulation to be more clear. But I think it's correct. It's not clear which family members, especially if there's a large family, it could be limited to.
Well,
yeah. Please go ahead. Just share. Sorry.
I happen to have the act in front of me. I carry it wherever I go, as it turns out. There is 82029 does define immediate family. It does limit it to spouse and dependent children, for what it's worth.
Oh, okay, good.
Aunts and uncles are not under immediate family. I don't know if we have a regulation that is more permissive than that, though.
Well, thank you, Mr. Chair, for your pocket version of the act. I'm sure that is helpful, because I've shared throughout the discussion of this both an appreciation for what I think the author is trying to do. Having, we had to install a security system. I had to go to court, to get safety, because members of the assembly at the time I was there, I was on a list that was, threatened and so on. But we did it with our personal funds. I understand that not everyone may be able to do that. Campaign funds are held in trust, and not having to at least report even after the fact about why this was done, and not having to reimburse at all for it does concern me. And the fact, again, that it's staff, and some staff could work there for part-time, they could work for 2 months, and then after they leave, the threat is gone, and the bill doesn't seem to address that. Has the author I don't know if we've actually gone back to the author with, can you change these things? Because I think as a commission, we need to reach some consensus. But do you have any indication at this point if they have openness to discussing that with us, some improvements in that area, both the reimbursement, the application of reimbursement to staff, and any kind of reporting or justification even after the fact to us that might be possible.
They have expressed interest or willingness to discuss a reimbursement provision. As to reporting, I think they thought it was sufficient that these expenses would be reported on campaign statements, but I can reopen that conversation if that's something the commission would like me to do.
If the chair still gives me the floor for a few seconds, and I certainly would give it back, I would like to propose that we request reimbursement of the, and I would say fair market value. Fair market value of a phone can change in 6 months, but the committee had to cut a check for X amount at the time. Maybe that's negotiable, but that there be a reimbursement requirement, and we'd have to obviously find out when that happens. I think it might be fair to either when the threat is no longer felt, or the committee closes, like whatever existing law is for other tangible assets. I would suppose whichever is sooner, but I don't have strong feelings about it. Just pursuing reimbursement. And the second one, maybe the reporting having to justify to the police first. I can understand if we remove that requirement, but I don't see why we wouldn't want to have at least the rigor of the requirement coming to the FPPC. So I personally would like to have a conversation with the author about that, and obviously welcome input, and I'm open to colleagues' suggestions.
For my 2 cents, I think having the to me, the biggest challenge I have in supporting this today is the absence of some kind of reimbursement. Like, that just sticks out as a sore thumb to me in the bill. I think with respect to verification, I think it is sad but true that we are in a time, unfortunately, where I think that the current system of having to get that type of verification ahead of time doesn't make a lot of sense. And I also think we ought to be encouraging public officials to be proactive in protecting their staff. And so I wouldn't want to create a situation in which one member of the staff may feel threatened for some reason, and everyone else who works with that person who could be subject to the same type of threat but hasn't received a specific threat wouldn't be eligible for some type of security measures. And so to me, it's sufficient if the candidate would verify in some way that they feel that this is necessary. So a simple attestation, I believe this is necessary, I believe that there are sufficient facts to warrant this. I think you have to kind of take people at their word at some point. But the reimbursement, to me, is important, that we at least try to work with the author to have some type of reasonable reimbursement. That's my 2 cents.
Yeah, I would agree with the points that were made by Commissioner Baker, as well as the chair. I mean, there needs to be some rationale in terms of reimbursement, but we don't want to bog down the process. And then you have a staff person, for example, who's having their life threatened and they weren't able to get a security system in place. So I think collectively we can come up with some kind of balance that makes sense.
Commissioner Wood?
Yeah, I agree with that. I think this really needs to be reimbursed. Otherwise, it sets some pretty nasty incentives.
Yeah. All right. Commissioner Baker?
Thank you for the great, thoughtful ideas. Agreed. Unfortunately, we don't have to start from scratch on reimbursement language. We have some parallels with other tangible properties. So I think that might save some effort. I agree with the chair on that sort of before you can get something, you have to meet other requirements of verifying. But I would like to see, even if it's after the fact, with the time period, some attestation that I believe there was a genuine threat, and maybe even a little bit of a description about it, without it really, because that would be subject to a PRA request. That could be something that would be publicly obtainable in addition to what the expenditures were on the reports. And I think that would provide some transparency that I'd be more comfortable with. I'd throw that idea out there and hope that the author is agreeable to helping us find something.
All right, Mr. Kano, you have your marching orders.
Understood. Thank you.
All right, go ahead and continue, please.
Okay, moving on. AB 83 by Assemblymember Lee. This relates to foreign influenced business entities. That bill is on the suspense file in the Appropriations Committee. AB 270 by Assemblymember Lee. This relates to public financing of campaigns, and this is a new bill since the last commission meeting. This bill would allow public financing of campaigns under certain conditions, including that a state or local governmental entity creates a dedicated fund for this purpose. The language is actually very similar to existing law passed in 2016 that was declared void and unenforceable as an improper legislative amendment of a voter initiative. AB 270 attempts to address this deficiency in the previous law by requiring that the bill go to the voters for approval if passed by the legislature. Also, unlike the 2016 bill, AB 270 would prohibit the money in a state or local government's dedicated fund from being taken from money that's earmarked for education, transportation, or public safety. The bill passed in the Assembly Elections Committee this week, 5-2. AB 334 by Assemblymember Rubio relating to codifying Section 1090 guidance for independent contractors, passed in the Assembly Elections Committee 7-0. We're continuing to work with the sponsors on this one to ensure that the language accurately reflects the case law and the FPPC guidance. SB 24.
Yes.
I apologize. I don't know if we have a question about a bill you'd rather we wait until the end of the entire summary or do it while we're on that particular bill. What's your preference?
If you have a question, go ahead and ask now.
Thank you. It is about AB 83. And this has some requirements from Assemblymember Lee about a new business entity certification responsibility and required receipt of certification. Did this bill pass and get sent to approps?
That's correct. It passed in the Policy Committee.
So, that's going to be another hurdle. Yes, I'm sorry. That's another hurdle it has to go through. So it may not be necessary to spend too much time on it at this point because it could move on from there, or it could die there, or be made a 2-year bill at that point. I just want to go on record at this stage, should it come up with the author, many concerns about the certification duty and the receipt requirement, and the way that it can really not only chill speech, but create numerous violations unintentionally that can increase our workload and have little to no public harm. And so I just raised concerns about that. I'm personally not sending you off to approach the author about it at this point, unless colleagues feel this strongly. But I'd like to see if this gets out of approps, which I think is sometime in May, that may be a time I may want to weigh in on it more, perhaps at the May meeting. I don't know if our May meeting is too late before House of Origin, but that's my comment on this bill. Thank you for letting me stop the train for a second.
It's okay. Thank you, Commissioner Baker. All right, go ahead, Mr. Khan.
Thank you. All right, next bill is SB 24 by Senator Umberg. This bill also relates to public financing of campaigns and is actually identical to AB 270 by Assemblymember Lee. I anticipate that at some point one of these bills will pull forward as the vehicle that they will continue with. The bill passed in the Senate Elections Committee 6-1. There was a question in the Law and Policy Committee about the fiscal on this bill and the other identical bill. Staff hasn't yet evaluated costs for this year's public campaign financing bills, but for the prior bill from 2016, which attempted to make the same change but without voter approval, the Commission's costs were recorded then as minor and absorbable. And since creating a fund for this purpose is voluntary, those costs would be the responsibility of the jurisdiction. This year's bills do require voter approval, as I mentioned, so the Appropriations Committee will likely consider the costs related to placing the item on the ballot. All right, next bill, SB 248 by Senator Newman. This is the bill requiring a new candidate experience disclosure, passed in the Senate Elections Committee 6-0. SB 251 by Senator Newman, prohibiting an elected officer from being employed by another elected officer with the same constituency did not pass in the Senate Elections Committee, that bill will not be moving forward this year. SB 328 by Senator Dodd, which would expand contribution limits to all local government agencies or would allow the agencies or jurisdictions to adopt their own limits, passed in the Senate Elections Committee 6-0 and the Senate Education Committee 6-1. This is the first of two bills that the Commission has been asked to consider supporting by the authors' offices, so I'll provide some additional information. SB 328 would expand the PRA's contribution limits to all local government agencies not currently covered by existing law. This includes school districts, county boards of education, community college districts, and special districts, or over 4,000 new agencies, though some of these agencies or jurisdictions will likely adopt their own limits. Because of this expansion to likely thousands of new candidates, Commission staff anticipate increased workload. In terms of the fiscal, the Commission is requesting 9 new positions, 2 in legal, 6 in enforcement, and 1 in the audit division. The FPPC voted to support AB 571 in 2019, a similar bill that expanded the PRA contribution limits to cities and counties. And to compare, the FPPC requested 6 new positions for that bill. The bill added a Republican co-author, Senator Ochoa Vogue, and is now a bipartisan bill. It's supported by the League of Women Voters and Common Cause and has no registered opposition. And I'll pause here for questions and discussion.
So I'm sure I understand this. So this would, just like local contribution limits that were passed before, the option of these special districts to impose their own limits would still exist. So if they wanted to have lower limits than the default state limits, they could do that.
Yes,
Correct.
They could enact any limit. They could enact a 0 limit or and possibly high limit, whatever they want.
Okay, all right. I just wanted to make sure I understood. Thank you. Commissioner Baker?
Thank you. I had that. They could also go higher. So you just clarified it, and possibly higher. But my question was, I remember with 571, there were issues about, we had to issue advice and authority because there was some confusion, or at least it wasn't covered about when it kicked in. At the risk, I'm sure we're not going to go through that again. So whatever we had to go through with that, I'm sorry to be so vague, but I think we have some recollection. We also try to hedge off at the pass here and let the legislature address more specifically or suggest to them, so we don't have the same what's retroactive, what isn't, which contributions count, which don't. That's my point of feedback, and I'm sure you've already covered that.
I agree.
Yeah, thank you for the comment. We have had those discussions with the author's office, and there's a section in the bill that applies the contribution limits only to contributions after the effective date of the act.
All right. Any other questions or comments from Ms. Nakano on SB 328? All right. Well, we've received a request from the author to support this bill. I think we should support the bill. I think it's important. It's consistent with our prior action with respect to local contribution limits. So I would move that we register our support for SB 328.
I can second.
Commissioner Wood, thank you. Is there any public comment on this motion before we proceed? Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Please proceed, Ms. Nakano.
Thank you. The next bill is SB 409 by Senator Newman. This relates to writing candidate statements in person and creating candidate video statements linked in the ballot pamphlet with a QR code. That bill passed in the Senate Elections Committee 6-0. There was a lot of discussion about that bill in committee, and the author committed to continue working on the bill, I believe, including to amend the bill to strike the first portion relating to writing candidate statements in person and to retain the portion relating to QR code video statements. So I'll keep the commission updated on any future amendments. SB 573 by Senator Wahab, a new bill relating to post-legislative employment restrictions, passed in the Senate Elections Committee 4-0 as amended. The amendments discussed in committee will notably narrow the bill compared to its original form. As amended in committee, the bill would prohibit a committee consultant designated in the Assembly or Senate's Conflict of Interest Code for 1 year after leaving office from engaging in any activity that would require the person to register as a lobbyist for influencing any matter under the jurisdiction of the former committee. So, for example, under this bill, a principal consultant in the Elections Committee would not be allowed to leave the committee and then come back and lobby on election bills for at least 1 year. There is one exception. The restriction does not apply if the former consultant is lobbying on behalf of a nonprofit organization.
If I may, before we pass on this one.
Yep,
okay?
Commissioner Baker.
Thank you. And I went and watched in my free time, I watched the elections committee's deliberations earlier this week. And I saw when this bill came up, I do know they have it's narrowed this to committee consultants in 1 year, but do you know if there was more language about if it's lobbying, if it's working for a lobbyist employer who will, do it, you can't have any contact with it at all? Do you recall if that was part of the additional limitation on the bill to narrow it?
The mock-up that I've seen based on that conversation, it's limited to committee consultants engaging in any activity that would require the individual to register as a lobbyist under this title, the PRA, for influencing any matter under the jurisdiction of their former committee. So that's the extent of the requirement. Yeah, and this is another one that's going to a probe, so I might renew my comments from before. I had a lot of concerns and continue to have them about this bill. It's going to go to probes. If it comes back, this may be one that I would really be interested in the details of where it's at that point. So I'll reserve it till then, but it's on my watch list. Thank you.
Mr. Kano.
Thank you.
Wait, I'm sorry. My hand's up. Too.
Yep,
Commissioner
Wood,
Wood
sorry.
Thank you. Thank you, Mr. Chair. I know that we're just right now reviewing these things, but am I wrong to think that having the exemption for 501c3 organizations basically blows the whole thing up? Because basically any group can create a 501c3 and then have the former official lobby on behalf of that group that has this exact same interest as the for-profit group. Just checking.
That's an interesting point. If I can ask that question to the author's office.
Yeah, I know there are different rules for 501c3s, 501c4s. I know they can both exist and for the same type of organization. So perhaps you can report back next month. And because I think that's a very, very good point, Commissioner Wood.
Thank you.
All right, go ahead.
Okay, moving on to SB 681 by Senator Allen. This is the bill that would allow PRA bills to be in print for 7 days before final voting instead of 12, unless they did not previously amend the PRA. That passed in the Senate Elections Committee 6-1. There was no fiscal on that bill, so it is on the floor. SB 724 by Senator Glazer, requiring disclosure of paid communications that identify state elected officers, passed in the Senate Elections Committee 6-0 and is now on suspense in the Appropriations Committee. All right, last bill, SB 858 by. Oh, yes, please.
I'm sorry. Yes, about this one, because I think it was the last meeting we had where I said, what a great bill. And I still agree. Do you have any indication that why I thought the original bill was elected officials in California, not just state officers, but I may be incorrect on that. I don't think that it's changed. I just maybe didn't pop up in my mind. Do you happen to know if there's a reason why it doesn't cover local electeds like city council members and supervisors and such?
I don't know why it doesn't appear that it is limited to elective state officers, but I can make that inquiry to the author's office. Oh, I think Commissioner Baker may be speaking.
Commissioner Baker, we can't hear you.
Yeah. Right. I was on mute. I apologize. I would be grateful for that. Sufficient for your time just to inquire if there's openness and perhaps there's a rationale, and because it does seem like something that could apply very wisely to local, and define local how we think is appropriate. But thank you.
To the extent, because I take from Commissioner Baker's question that we may want to propose that they include locals if we think, right? I would like to know, if you're going to ask them about that, I'd like to, at the same time that information comes back, know what if there would be a change to the fiscal impact to our agency would be if we went from just state to local as well. Because as we just talked about a few moments ago about the change with local default contribution limits, one thing we were just talking about cities and counties, all the special districts, now we're talking about 4,000 new entities, and that's why our fiscal exploded on that more recent bill. So I just want to keep that in mind.
Thank you.
Thank you.
All right, Ms. Nakana.
Okay, last bill is SB 858 by Senator Neelo. This is also a new bill. It would transfer the duty to prepare the official summary of measures that will appear on the ballot from the Attorney General to the legislative analyst. It also makes similar duties, it would also transfer similar duties that appear in the Elections Code. And the whole bill is contingent on the passage of another bill, SCA 3, that makes similar amendments in the California Constitution. As I mentioned, the author's office requested commission support on this bill and its companion bill, SCA 3, so I'll provide some additional information. The bill passed unanimously in the Senate Elections Committee 7-0, and the staffer informed me that they will be adding a Democrat member as a co-author. The bill is supported by the California Chamber of Commerce, the League of Women Voters of California, and the Howard Jarvis Taxpayers Association. There is opposition from the California Nurses Association. According to the author's fact sheet, there have been numerous instances of the AG's labeling of an initiative title and summary swaying voters in an intended direction. For example, Prop 22 in 2020 exempted Uber, Lyft, and others from providing contract workers with employee-like benefits by classifying their drivers as independent contractors rather than employees. The original title by the Attorney General's office was Changes Employment Classification Rules for App-Based Transportation and Delivery Workers, but the final title was Exempts App-Based Transportation and Delivery Companies from Providing Employee Benefits to Certain Drivers and Delivery Workers. Another example, Prop 93 in 2008, the former Attorney General titled the measure Limits on Legislators' Terms in Office, which implied the measure was shortening terms for legislators when it proposed to lengthen terms for many sitting members. The Legislative Analyst's Office currently has some similar duties, including duties to prepare summaries of the general meaning and effect of yes and no votes on each state measure, and an impartial analysis of the measure, including a description of the measure and a fiscal analysis. The bill would make changes to one section of the PRA and 22 sections in the Elections Code, all making similar changes relating to preparing titles and summaries for ballot measures, and the author has requested commission support for this bill and its companion bill, SCA 3. I'll now turn to the commission for any questions or discussion.
Commissioner Wilson?
Is the Attorney General in support of this measure?
As of the committee hearing this week, there was no position by the Attorney General's office.
Okay. Unlike some of our commissioners, I didn't have a chance to go to watch the last hearing, committee hearings. But my question is, what is the rationale for moving it from the AG to legislative analyst? Was there any discussion about that? Or?
I think under the opinion of the author's office and the committee, since they passed the bill, there have been instances of an appearance that the AG is putting a spin on ballot titles, summaries and titles that may not be considered neutral.
I was making that assumption. What would be the? I didn't have my mic on. You eloquently stated kind of what my assumption was, but moving into the LAO isn't necessarily going to change, this issue because the LAO is appointed by the legislature. So, just food for thought.
You mentioned a couple ballot titles and summaries as part of your presentation. From my former life, I know very well that when people don't like ballot titles or summaries that they think actually are not fair or impartial. There's a process by which they go to court, and a judge who's non-political and independent makes that determination. Did either of those ballot labels or titles go before a judge who actually decided that there was something wrong, or is it just, it's more of an opinion with respect to those two?
I don't know about those two in particular. I pulled this directly from the author's fact sheet. They did point out that that process does exist, and in 2020, the Attorney General was sued 6 times for ballot title and summaries, and since 2008, there have been over 20 lawsuits against the AG over labels, titles, and summaries. Relating to the 2020 lawsuits, the Superior Court judge wrote that the court is not a copy editor and then denied hearing half of the suits, according to the fact sheet. So the process does exist, and it appears that it is used.
Right. All right. Well, I guess my perspective on this is I don't believe really that attorney generals who do this are intentionally trying to sway things one way or the other. My personal view is that lawyers, if every lawyer in this room was given the task of writing a summary of something, every lawyer is going to write it slightly differently. And the question is it fair or impartial? Where I think this bill would move us, which would be useful and beneficial, is eliminating the perception and the discussion about that issue, and potentially improving the integrity of the elections process by taking it out of somebody who is an elected official and instead put it in the hands of somebody who presumably would be more neutral. So I do, policy-wise, I can see why they're doing it. I think it is almost entirely for the benefit of perception, which is important when you're talking about the integrity of elections. So that's my 2 cents on it. Commissioner Baker?
Thank you. And I agree. And first, this reminds me to just for my colleagues, I did have conversations, I should disclose ex parte, with Senator Nilo and Senator Glazer. On this bill, I think it's a great policy, but not just because of the perception, which is a huge and important issue right now. That's a great point of the chairs. I know in other states where maybe there's Republicans that are in control of doing it, and they might skew it either intentionally or unintentionally. So I don't think this should be a reflection of the current occupant of the AG office. I think it's more a reflection of when people have the ability to do these things and they're in the political world and they may get pressure from others, or they have their own beliefs and biases, they may write things away. And this adds another layer of trust to and we are entitled the Fair Political Practices Commission. I think it is a good one to support. I would move that we support this bill, and I hope that it not passes. I don't think we should weigh in on the ballot initiative itself, which is a separate piece of legislation, because I think we will, technically we'll have jurisdiction over its, reporting and so on. But that is my belief, and I'm thrilled that it has bipartisan support. I was very surprised by that, because in prior efforts, this hasn't gotten much traction. But that's my motion, and thank you.
Commissioner Wood, did you have something you wanted to add?
No, I mean, I think their counterfactual is pretty optimistic, kind of the way you were talking about that, Mr. Chair. But I don't feel strongly either way, so I'll kind of go along with what everybody wants. Like, I just don't know that it's going to solve any problem. I think it's largely about appearances, but I'll go along.
Commissioner Wilson?
I think Commissioner Baker makes some excellent points, but whenever the FPPC requests an opinion, we go to the Attorney General. We have a long-standing working relationship with the Attorney General's office, and I think if we're going to support this bill, we should see how it moves through the process, because quite frankly, this is a bill that I think just shifts the problem elsewhere. You could have former Attorney General's staff, not necessarily the attorneys, working in the legislative analyst's office. You would have lawsuits brought by, a constituent who wants to challenge down the road, an analysis of a ballot measure, for example, and then you have the legislative counsel going to court on behalf of the legislative analyst. So, I don't see this bill as, it might address the perception issues, but I don't see it resolving the problem. And my own position would be to delay taking a position in support or opposition of this measure at this time.
When is the next time that this bill is scheduled to be heard in a committee?
This one is scheduled to go to the Appropriations Committee, which will be in the next couple weeks.
What about the next substantive committee? Because the Appropriations Committee is going to be worried about presumably the fiscal impact of this bill moving duties over and then putting a question on the statewide ballot, right? So more substantively, the substantive policy, when's the next time that's going to be heard?
Sometime probably end of May.
Commissioner Baker, in light of Commissioner Wilson's concerns, would you be willing to have the motion heard in May?
I absolutely would. I appreciate our colleagues, thoughts on it. And I think it can still be a good conversation to have in May. So I suppose I can withdraw my motion, whatever the parliamentary way to do it is. I have no problem with that at all. I respect my colleagues' views. I will say I don't think it's just a question of perception. I do think that's a great point, and that I do think this could change things. I know I worked a little bit on this when I was in a policymaking role, and I think every editorial board in California that's looked at this has weighed in support for what that's worth. And they'll list long examples of how under both Republican AGs, which happened in a distant past, and more recent Democratic AGs they feel skewed things. And I think AGs are, again, not a reflection of the individuals, but the office and having power. They are going to get pressure from their folks to portray a measure a certain way without much accountability beyond it. And I'd love to see an independent arm be able to do that. So I want to just get on record, because I did say it was great for perception. I think it's great substantively. And I have zero problem with Commissioner Wilson's points and moving it to May to hear that. I think that is still before House of Origin for what that's worth.
I'm asking Ms. Nakano to confirm for us before we move on. That way we just know it's before House of Origin.
Yeah, June 2nd is the last day for each house to pass bills introduced in the House.
Okay.
And with this, if I may ask, would this bill be necessary in order for the ballot initiative to even go before the voters? This isn't authorizing that to go before the voters. Is that a separate vote?
Yes, that's separate. This bill it would not take effect unless the constitutional amendment also takes effect. I don't know if the constitutional amendment is contingent on this bill as well. Just take a look at that language again. Other way too.
All right. Thank you, Mr. Nakano. And Commissioner Baker, you have my commitment. I know next month, as I recall, you're on a short time frame with us next month. So we will take this up within the time that you're able to be with us next month.
I appreciate that, and I'll be on time and in good technology connection for the meeting next month. It's starting an hour earlier than we typically do.
That's right. All right. Thank you. Any other questions or comments for Ms. Nakano on item 8? Hearing and seeing none. Thank you, Ms. Nakano. Appreciate it.
Thank you.
All right. Moving on to our executive staff reports. Item 9. Mr. Burton, welcome back. Hope you had a chance to sneak out and get some lunch.
Oh, not yet. Ready for that. Thank you, Chair and Commissioners. I just want to point out in the Enforcement Division's report that we have revamped a couple sections just to make it more reader-friendly. And as I stated earlier during the Enforcement Division update, we've also added a monthly report as to the number of sworn complaints that where we needed more time beyond the 14 days. Besides that, my report is as submitted.
All right. Thank you, Mr. Burton. Any questions for Mr. Burton? All right, as submitted.
Thank you.
All right, Chief Shaw, good afternoon.
Good afternoon. My report is also as submitted, but I'll be happy to answer any questions you may have.
All right, any questions or comments for Chief Shaw? Hearing and seeing none.
Thank you.
Thank you. All right, moving right along, Mr. Bainbridge, Legal Division.
I'll follow suit. I don't have anything to add.
You sure? You don't want to talk about your history with the collections procedures? Any questions or comments for Mr. All right, hearing and seeing none. Thank you, Mr. Bainbridge. All right, admin and technology, Ms. Hahn.
I would like to submit the report as is, but I would like to provide the commission an update from the last commission meeting we had, which was the discussion on a traveling meeting that might be at the fall of this year. So staff have reached out to multiple entities, and thus far we have received commitment of hosting us are City of Fresno, City of Benicia, Kern County, City of San Luis Obispo, and Ventura County. And then, so staff will come back later on and provide an update to the location and the month that we'll do the traveling meeting.
Thank you, Ms. Hahn. Before we leave this, just do any commissioners, you have thoughts on those locations? Are there other locations you'd like Ms. Hahn to examine geographically? Commissioner Baker?
Are we talking about hitting all of those locations, or they've
No.
just accepted the invitation?
We have to pick one.
Okay, gotcha.
The beach or Fresno?
Okay. Well, as I mentioned, I do think it's important that our Central Valley brethren and sisterin and such we don't want them overlooked. I don't see a particularly, I mean, I know they're slow in Ventura, Southern California location. I feel like people in Southern California shouldn't be ignored despite the fact that they're Dodgers fans. But I otherwise don't have a preference. Thank you. I'm flexible.
Yeah, since I'm based here in Sacramento, I would defer to Commissioners Wood and Baker in terms of what would be convenient, for them in terms of travel. Because I think for us, we have more flexibility.
All right, Commissioner Wood, speak now or forever.
I mean, I wasn't under the impression that this was about convenience. I mean, I don't know. I'll go anywhere. I kind of think that Commissioner Baker might be right about the Central Valley. I also really enjoy going to SLO, so I'll do whatever you guys want.
All right. Appreciate the feedback. We will work with Ms. Hahn to identify the best location for us to have that traveling meeting.
If I could just add this, I mean, Benicia, lovely city and very, very valid. Perhaps we'll hit it someday. It is closer to the Bay Area, so I feel like if we're going to really do some travel to get to constituencies that wouldn't have an easier time coming to Sacramento, for what that's worth, I'll leave to you if that is a factor. But it's and convenience, I can go to any of them, but maybe, yeah.
All right. Thank you, Commissioner Baker. As Mr. Bainbridge reminded us the other day, or at least when I was talking, apparently Benicia used to be the California state capital. So there you go. Random California trivia for the day.
No, but that's an excellent point, because their historic state capital is still in Benicia. And when the state celebrated the 150th anniversary of the state, what's that, the sesquicentennial, the legislature met in Benicia at the historic state capital. So I'm not saying we would meet there, but if we do go to Benicia, I think all of you would have an interest in at least maybe seeing what the former state capital looked like, or continues to look like.
Yeah, that's a good point. That's a good point. All right. Anything further for Ms. Hahn? No. All right. Thank you, Ms. Hahn. Appreciate it. All right. Last but not least, Executive Director West.
Thank you. You've heard plenty from me today. So that's everybody's been working hard and it's going really well, and nothing new to report.
Thank you. Any questions for Executive Director West? All right, brings us to our final item, commissioner comments and proposed future agenda items. Any commissioners wish to propose future agenda items or make closing comments? All right. Do I have a motion to adjourn?
Move to adjourn?
I will second.
Second.
Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Madich.
Aye.
The motion passes.
All right. Thank you, everyone. Great job. See you all
Thank
next month.
you.